Hey, folks, and welcome to another episode of Hangouts and Headlines. It's been a couple weeks, so we have a few more lawsuits to talk about today with respect to Blake Lively versus Justin Baldoni, but we're only going to be really focusing on one, and that is Blake Lively's return volley against Justin Baldoni after his lawsuit against the New York Times for defamation. I know things have advanced a little bit past there since we last talked, but we're going to try to focus on that particular aspect today so that we can focus on the rest of it in a future video. Remember, I only did the first video because I wanted to talk to you all about leaks and coverage of things at the New York Times. That was before a defamation lawsuit, certainly before a harassment lawsuit that we're going to talk about today, and then a second defamation lawsuit. So we've got a lot on our plate with respect to this particular topic, but we're going to try to focus down and talk specifically today about Blake Lively's lawsuit against Team Justin Baldoni for sexual harassment and retaliation. With that as our introduction, how are you all doing today? This is a Hangouts and Headlines, so we start with a Hangouts portion where we can check in with each other, see the community, talk about how we're doing, and maybe ask some questions of each other. So how are you doing? How's the weather where you're at? How's January treating you? And 2025 overall? I want to hear everything because, frankly, Michigan is cold, Michigan is dark, and I like hearing about places that are not cold and dark. So let me know in the chat, and we will start our Hangouts, and then I have a few questions for you if we need to continue the conversation in a different direction. First, we've got Henhouse Bath Company saying, good morning. Good morning, Henhouse Bath Company. Always good to see you. June B says, as I slog through end-of-year taxes, your take on this will keep me company. I'm very sorry about having to deal with taxes. I know that's always a fun period of the year. I also hate the transition between months because I have to reconcile all my budgets and do all that fun financial stuff that they never talk to you about when you're just lawyering at a big law firm. So I am very sympathetic to your plight, June B. I hope this commentary can help keep you company because otherwise that really is a slog. Henhouse says it's raining in Nashville, but feeling good. I think there's always a nice way to experience rain. So I'm hopeful that that rain is nice for you today. I'm glad you're feeling good. It's important to feel good. I don't always feel good. You might have noticed I didn't do a stream on this topic or any other video last week. That was a week where I was very much not feeling good. So I'm glad to be feeling good now. But we need to be positive about those things. We need to take advantage of those times when we do feel good. So I'm glad that you are feeling that way today, Henhouse. Brianna Bourne says good morning. Anna Karen says afternoon, Rick. I always love hearing from different time zones. Always a nice reminder that people are experiencing different things around this great globe of ours. Good afternoon, Anna. Newspin says morning. It's also cold, but not quite so dark here in Utah. It's not technically dark this moment in Michigan. It just feels dark all the time in January. But I'm glad to hear it's not dark in Utah, Newspin. Emily Aaron says good morning. Across the big lake from you over here in Wisconsin, and we're getting up to 50 degrees today. Sunshine emoji. I'm always glad to hear that from Wisconsin and Illinois and the places to our left or west, if we're being, accurate about these things, because that weather tends to come to us in Southeast Michigan in the course of a couple days. So I'm glad to hear you're getting some warm weather. I always think of Wisconsin as covered in snow, but it doesn't sound like it if it's 50 degrees or we'll get there. HP says it felt like spring in Iowa the last couple of days, which is unacceptable in January. I know it can be off-putting. I would love some of that spring breeze here. June B says, Colorado is cold, but we have some sunshine usually. I hear that. I'm glad. Sunshine is interesting in the winter because it looks nicer than it is outside. It's often colder when it's sunnier rather than cloudy. But cloudy, overcast, and snowy just depresses me, honestly. It's just a sad feeling. It's a dark feeling. And I would prefer to have some sun, even if that makes it really, really brisk walking outside. Melissa says, hi from Germany. Hi, Melissa. Hope you're doing well. Britt Cormier says, Hoeg, always good here in Colorado. I love the winter. Yes, I love the cold and snow. Hey, to each their own. Back into grinding Warframe, which is the greatest, grindiest grind to grind when you cannot be outside. Warframe being a free-to-play video game that is one of those games where you grind for currencies to get other aspects of the video game unlocked to you. I hope you're having a good time, Britt. I just did a video in Virtual Legality that released this week about loot boxes and an FTC settlement with the makers of Genshin Impact about how free-to-play games might be under at least a little bit of, let's call it consideration, if not attack, from the U.S. regulatory apparatus, and we don't know how that will proceed after the change in administration. But if you're interested in that topic, please do check out that video. HP says, but at least I should be able to play The Sims 2 re-release tomorrow. There have been rumors on the anniversary, I want to say 25th anniversary of The Sims, that they're going to re-release The Sims and Sims 2 very soon. So if you like those original games, keep an eye out. Those might release very shortly. Ms. VG3 says, perfect weather in South Florida for a change. Glad you're feeling better. I'm glad to be feeling better. It is off-putting to just suddenly not be feeling good about what you're doing or what jobs you have or what work you have. And I wish I could get used to that, but I have not so far. And I'm very glad to be feeling better talking with you all today. Travis says, cold and dark here in Northwest Ohio as well, but happy to be joining in a live Hangouts and Headlines for once. I'm very happy to have you here, Travis. And then we have a member chat from, who's this guy? Thomas Hoeg. Hey, Dad, how are you doing? I hope you're having a good time in much more warmer climes than Southeast Michigan. We are here. Let's have some fun. Let's have some fun. Let's have a good talk today. Let's have an enjoyable talk about some not enjoyable topics, but we can still have some good understanding of law and process and what these people are dealing with, even as we talk about those topics. Thank you, Dad. I appreciate the support. Emily Aaron says there's no snow here currently. I'm sure that we'll get some more of it sooner or later. We still have at least a few months of winter left to go. We do at that, yes. I always consider the end of January to be a bit of a marker. January seems to be the toughest month for me to get through psychologically in the winter. But there is no doubt that February, March, and even April sometimes can have significant winter effects if you're in Michigan, certainly. Laura Boyd says it's Northern Virginia here, up to 50 when the past 2 weeks had highs in the mid-20s. Crazy weather we're having here. Yeah, it can be off-putting, and especially when there's large swings in temperature, there can be a lot of wind, and that isn't the best. But I could use some warmer temperatures here, certainly. Melissa says we've had some bad frost, turning to rain, turning to frost in the last weeks in Germany. Not ideal for living on a steep hill without a car. Yeah, I can imagine. Be careful out there. It's easy to hurt yourself on ice, so watch where you're going. I have to take a flashlight basically everywhere I go to make sure I'm putting my feet down in a place that won't make me slip. So do be careful. Brett Cormier says, I think DE will be good with its monetization of Warframe. That is Digital Eclipse, I believe. Everything that matters can be farmed. It is pay to sleep, not pay to win. Laugh out loud. Yes, I certainly understand that. And I think that for the most part, when we look at the Genshin Impact complaint, we see a focus on gotcha mechanics and those randomized loot boxes over and above just pure grind. And I suspect that most will be okay, but certainly that's got to be a wake-up call to a bunch of aspects of the video game community if you look at what the Genshin Impact developers actually settled on as the complaint from the FTC. New spin was my initial thought was that the next administration has other things to do rather than worry about loot boxes, but they seem to be doing everything else simultaneously, so who knows? Yes, as we like to say here, reasonable minds can differ on everything, including politics, so we're not going to talk too much about policy of the new administration or the old, but I do think that it is likely the Federal Trade Commission under new leadership will not pursue some of the things the FTC did at the end of the last administration. I think that is clear. Mrs. Hoaglaw, good morning, honey, says, good morning, everyone. I keep planning fake vacations in the hope that the warmth will make its way here. One of the things we do like to do in the winter is plan vacations or vacation time so that there's something to look forward to. I always recommend for people, including my kids, my wife, and everybody that is a friend of mine, to have something to look forward to, whether that's a movie, a video game, a book release, a vacation. Have something on the horizon that you can look forward to when you're not having the greatest time. And I can say that now because I'm not always great at it in my own personal life, but try to have something to look forward to. So yeah, plan those fake vacations, dear. We'll just see if I can pay for them. All right, let's ask a few questions before we get into the weeds of substance here. First, with respect to Lively versus Baldani, have you seen It Ends With Us? What did you think of it if you did? I have not seen this movie. It is not aimed at me demographically. I really had no desire to see it, but I am curious. And as a corollary to this, I know it's based on a book. Did you read the book? Did you like it? I would love to hear from you if you have any experience with this piece of content outside of these two celebrities yelling at each other in lawsuits. Sarnism says, I have less than no interest in the movie or the book it's based on. That's fair. That is a fair statement. I can appreciate that. But has anybody seen it? Chaos Wrangler, didn't see it, not interested, would consider the book. Okay. Not interested in the movie, would consider the book. HP says, everything I've heard about the book made me not want to see the movie. All right. So we don't have a lot of book readers, this particular book, or movie watchers in this particular chat. That's okay. Certainly not a requirement to having this conversation. Big Z says, nope, never seen it. Just heard the controversy. It's fair. Interestingly, this movie, as we saw in various parts of the lawsuits and the reporting, has been deemed a success. It's made $350 million in box office. That's not profit for the companies that made it. But it is successful for what appears to be the budget for this movie, which is substantially less than that. So somebody has to have seen this movie. Somebody has to have watched this both in the box office or on Netflix, because I know it's available on streaming now. So I am curious. Britt Cormier says, seen it? No. Will see it? No. Read the book? No. Care one bit about this story? No. Okay, Britt, fair. Just want to hang out with Hoeg and friends. Heck yeah. I appreciate it, Brett. I do. Thank you so much for being here and for having conversations with us, even if you don't care so much about the underlying substance of the conversation. That's one of the nicest comments that I can get. I got a comment like that on the virtual legality episode I was just mentioning with respect to the FTC and Genshin Impact, where the person basically said, I don't care at all about video games, but I like learning about legal process and the way that you talk about these things. That is such an appreciated comment. I really, really love hearing that people are getting something out of these videos, out of this content, even when they don't connect with the underlying subject matter, because ideally, that's why we're having these conversations, right? Ideally, we're talking about reporting in this context, although there's a lot of law here because there's been a lot more lawsuits than I expected. Or in virtual legality, we're talking about statutes, how the U.S. government works pretty often, how the legislative and executive branches pair up or not so much. We'll probably have more on that in the future. I have to be a little bit cognizant of political conversation points when I dive into those topics, because I don't want to be a place on the internet where folks just yell at each other, where folks just have outrage towards each other. So I really try to be very cautious about the topics that I cover that have those political touch points. But there's enough going on with executive orders. There's enough going on with various confirmation hearings and other things in the new administration that I think there is stuff to talk about. I might launch a new show based on that concept. We'll see. But I very much am thankful for everyone who is here, who doesn't care about the underlying subject material, because that means that I'm adding some amount of value to their lives and to the understanding of these kinds of situations. So thank you so much. And speaking of thanks, Sandy giving 5 Hoeg Law memberships. Part of that virtual legality episode that I did earlier this week was a test run of having those kinds of episodes that are maybe a little bit more evergreen, not so on the nose for news topics of the day, be available for a short period of time for members only before they go public, because I still want to educate and inform and hopefully entertain the public. But I want to give value to all the people that are supporting this channel, whether here at YouTube through memberships or through Patreon or Player. And I really want to give that value because over the last 2 years, I haven't been able to be as consistent in making videos as I was in 2022 and beforehand, when I was really getting so much support through those systems. And one of the things that I thought could really work there was to have these membership only videos for a short time, just really a day or two. And so I really appreciate gifting Hoeg Law memberships. I really appreciate those that sign up for memberships. My intent is for that to be a bigger pillar of support for the channel, with the public still getting everything that I do ultimately, and certainly still having live streams like this one, but maybe having a little bit more membership value. And that means the world to me that you're gifting these memberships, Sandy. So thank you so much. I really, really do appreciate it. And with that said, oh, we do have somebody that saw the movie. Sylvia, I saw the movie. It was the kind that one would be just as happy seeing on TV. Didn't need the big screen. That's one of the issues that streaming and box office has right now, is that for the most part, because streaming is so good, because people's TV setups and seating arrangements or what have you are so good, that a lot of people seem to only be wanting to go to the box office for whatever the equivalent of that year's Avengers movie is, right? Where you've got the Dolby surround sound, you've got the huge screen and all of that entails, and not so much for people sitting around on park benches or people talking in a cafe. And I don't know if either of those scenes are in this movie, but that's what I think of when I see kind of clips and screenshots of this movie. So I can understand that. I think my mother, who may or may not be watching this video at this time, watched this on an airplane screen and didn't seem the worse for wear for it. So I hope if you saw it, you enjoyed it. I hope it's good content, regardless of legal fights, regardless of the artists involved. I always hope that the media that they produce winds up being satisfying and good. I know that there are reasonable minds that can differ on that score and want to boycott things or otherwise want to have political stances in the media that they consume. I've never found that to be terribly effective for me personally, and I'd rather root for these things to succeed. So even if this is a complete tire fire, even if there are 5 lawsuits we could talk about on this, and there are, I would still hope that the underlying media that came out of it is somehow satisfying, useful, or good for somebody else's life. Oceani62 says people are more comfortable at home. I hate cinemas now. People look at their phones and misbehave in cinemas. They really do that more often than they used to. I don't know if that's a pandemic kind of function, but they do appear to be less cognizant of whatever impact they're having on those around them. And I had a person in a movie that I just recently saw that turned on their flashlight. I don't know for what purpose, but you really want to destroy the mood, ambiance, or experience of seeing something in the cinema. It's having a giant flashlight next to you, kind of scanning the seats and seat backs of that movie theater. Mrs. Hoaglaw tells Rebecca the same. Wicked is still out here. We'll probably take a Hoagling this weekend when she is done with finals. Our oldest adores Wicked. We have seen it many, many times and have gone to the theater many times, or my wife has, even after we got it on home video. So it is a big movie. That is the kind of thing that I think does have certain advantages seeing in the cinema. But I don't know that this movie, It Ends With Us, is that kind of movie. Kelly C says the bad promotion of the book turned me off from ever wanting to see the movie. The promo for the movie made it worse. I don't know anything about the promotion of the book, Kelly C. What was that like? I'm honestly not familiar with book promotion in general. I think the last time I saw any book being promoted, it was one of the Harry Potters with like midnight releases and parties at the Barnes & Noble and that kind of thing. But what was this promotion like, if you can let me know? Otherwise, I can look it up later. But I really don't know anything about the book promotion. Continuing with the cinema topic, Henhouse says, I do not enjoy going to the cinema. I'd rather stay home and see it in my PJs. I certainly understand the comfort argument. I think for me, I still view the movie theater as a kind of special, almost theme park-like experience that was available to us as kids and really made the day feel special, that we went out to the movies today. So I'd still like to see that succeed, but I honestly think that the movie studio industry, like the people that make movies, are killing that box office. I don't know why they're doing it. I think they're maybe a little bit short-sighted, but they're going to streaming so fast that I think they're just killing the box office, and by killing the box office, killing the movie theaters that make up that avenue for a market for them. And I don't know why. I think it is a mistake, but certainly other people and the experiences that you have at movie theaters is a part of the equation for why people aren't going. HP says midnight release parties at Barnes & Noble are making a comeback. Went to one last week and will go to another in March. See, I'm really out of the loop on this. I don't even know what book could have had a midnight release last week, let alone one in March. But I'm glad you're having fun, and I hope those books do well. I love reading. I love books. Donna J says, I went to 2 Harry Potter midnight releases. So fun. Yeah, I remember them having like bookmarks that they would hand out and pins about what you thought was happening in the book plots and what have you. And so that was enjoyable. I like people celebrating really all forms of storytelling, but certainly reading is high on my list. Emily says, I did not even know the book was a thing until the movie, but I thought the way the movie was promoted was incredibly tone deaf. I tend to agree. The Bring Your Florals, I use that as one of my marketing lines for these videos because I thought that was so kind of off-putting for what this movie is apparently about being domestic violence. Ossiani says, I'd see Dune or Avatar in the cinema, and that's about it. Yeah. Those movies definitely benefit from a big screen. Oh, I've got some information about those release parties. The Fourth Wing series just had a release party. I don't know that one. And March should be the new Hunger Games book. Thank you, Nicole. I appreciate that. I didn't even know there was a new Hunger Games book. I only recently saw the Hunger Games prequel movie. So that's interesting. All right, let's get this question off our screen and let's head into talking about the way we report on things. And of course, lawsuits, right? So the Associated Press are the makers of the headline I put on the thumbnail to this video. Blake Lively sues It Ends With Us director Justin Baldoni, alleging harassment and smear campaign. A couple interesting things in that headline already. One is that Justin Baldoni is just the director in this. We've seen the New York Times and others kind of struggle with saying director and actor, making kind of long run-on headlines. The Associated Press just goes with director here. That changes things a little bit, but puts into context for our understanding that this is a position that is generally thought to have control, right? When we talk about harassment of any kind, in this case, sexual harassment, one of the things we're concerned about is power differentials, right? The clearest indication of a harassing environment is that someone with power over you and your future and your environment is doing this bad thing to you. So Justin Baldoni being labeled the director is already at least one editorial choice towards justifying the harassment lawsuit. That's not wrong. There's nothing inaccurate about this description, but it is a choice that's made. And we do try to point those out when we see them. Actor Blake Lively sued It Ends With Us director Justin Baldoni and several others tied to the romantic drama on Tuesday, alleging harassment and a coordinated campaign to attack her reputation for coming forward about her treatment on the set. Backing up a step, remember where we left this story was that Blake Lively and her team had apparently, at least it looks like, leaked a complaint document that they had filed with the state of California to the New York Times for purposes of getting the New York Times to report on that. The New York Times did so, and in reporting on that complaint document, Justin Baldoni says that they were defamed. So he sues the New York Times in California. We talked about the anti-SLAPP statute there and why I think that lawsuit is likely a non-starter. But as part of that lawsuit, Justin Baldoni said, look, if they had really wanted to pursue this course of action, if they really thought they were sexually harassed or retaliated against, they would have filed a lawsuit already. And in this particular case, this appears to be the response to that. The federal lawsuit was filed in New York just hours after Baldoni and many of the other defendants in Lively's suit sued the New York Times for libel. So this is shortly after the last lawsuit that we talked about in this series. And there is a playlist on the channel for this if you want to see all the videos. But I couldn't cover it at the time because we can only really do one of these lawsuits at a time in this long form format. So we're going to talk about this particular lawsuit today. One thing that's going to jump out at you is how closely it mirrors the language in the California Commission complaint, even though, as I've highlighted here, this is a federal lawsuit. It doesn't need to follow California law. It doesn't follow California law. It's filed in a federal court, which doesn't have the same kind of anti-SLAPP restrictions, doesn't have the same kind of evidentiary or other complaint requirements that a lawsuit in California would. And one thing that means to me is that the complaint itself didn't need to be filed in California in order for this lawsuit to happen. And I think that's kind of unclear in the reporting here, that you'll see it referenced that the complaint in California was required to file their lawsuit. That's correct if you're filing in California, that you actually have to get permission essentially from their regulatory apparatus to pursue an employment complaint in certain contexts because they want to have first crack at investigating and from their perspective, helping you out before you go and do a different discovery process and sue in the state of California. But if you're going to sue in federal court, a different jurisdiction in the state of New York, you didn't need to go through that process, even though this article is going to call the California complaint a predecessor to her new lawsuit. Now, again, I would point out that that's not inaccurate insofar as anything happening before anything else is a predecessor technically, right? You can always say that with respect to whatever you're reporting on, that this video is a predecessor to Friday in some important respect. And that's not wrong, but you're watching this video, my making this video, does not actually cause Friday to come into effect. And so the California complaint document is a predecessor to her new lawsuit in that it occurred first, but it's not a required pre-concept, and it doesn't lead from one point to the other. So all the reporting on that complaint document as a lawsuit itself was inaccurate. We know that. We knew that from the first video that we made. But now kind of connecting the two is at least a little bit misleading, even though, as we will see, the federal lawsuit uses a lot of the language that was in the complaint document to begin with. And that makes sense. You don't want to pay lawyers to redraft documents on the same set of facts. Lawyers are expensive. We are what is known as a cost center. We take money from the enterprise, whether it's an individual like Blake Lively or a company like Wayfarer. And so you don't want us to draft the same kinds of documents multiple times. But it maybe doesn't fit the bill perfectly when we see what's actually happened in the document. Now, a spokesperson for the Times, in response to the defamation lawsuit Baldani filed against them, said that their story was meticulously and responsibly reported. Further, they said to date, Wayfarer Studios, Mr. Baldani, the other subjects of the article, and their representatives have not pointed to a single error. Now, if you've watched this video series, you know that at best, that's misleading. I wouldn't expect anything else from a spokesperson. That's really their job, is to be slightly misleading while still mostly telling the truth as to whatever benefits their client. But in this case, we know that Baldani's lawsuit said that they got some of the emojis wrong, got the text context wrong, and were essentially just repeating the allegations in the complaint document. You can agree or disagree with that, but from the perspective of they haven't alleged anything to be wrong, that I think is inaccurate. And the Associated Press deserves credit for following up that spokesperson's statement, not just letting it sit there, but with a paragraph that says, but Baldani's lawsuit says that if the Times truly reviewed all those private communications, they would have seen incontrovertible evidence that it was Lively, not plaintiffs, who engaged in a calculated smear campaign. And that's one of the things that makes this story so interesting, is that not only did it appear that Team Lively leaked the complaint document to the New York Times, and there are various social media accounts and other things floating around online that suggest there's other evidence that it got leaked to the Times early and that the Times was working with Team Lively on it through the dates of the pictures and things like that. But regardless of that, it does appear like the New York Times was getting information that was maybe not publicly available. Lively, the Associated Press notes, is not a defendant in the New York Times libel lawsuit. Not that lawsuit. We'll see at the end of this video that she's a defendant in a different lawsuit for more money. But this is just an ongoing PR fight done through our legal system in a way that I think we can talk about, but that maybe isn't the most effective use of public court resources. Now, Baldani's attorney has certain issues with all of this, and this Associated Press article is now talking specifically about the defamation lawsuit against the New York Times. It says, in doing so, in reporting on this the way they did, the New York Times predetermined the outcome of their story and aided and abetted their own devastating PR smear campaign designed to revitalize Lively's self-induced, floundering public image and counter the organic groundswell of criticism amongst the online public. He added, the irony is rich. Not so much for his client, of course, but this is how lawyers talk, right? This is the lawyer on the courthouse steps putting his hand in the air and telling you, my client is absolutely hurt by these false and baseless allegations against them. And isn't it ironic that the ones that are accusing my client of conducting a smear campaign are themselves conducting that very smear campaign through the auspices of places like the New York Times? And so I think this article does a better job of kind of describing the framework of this story, but we still need to dive into some documents here to understand what's happening from Blake Lively's perspective. So thankfully, they linked the lawsuit. Let's take a look at the lawsuit itself. Like the other lawsuits we've discussed as part of this series, I have not gone through it in its entirety and highlighted things in advance. We're going to basically react to this as we look at things, but I have scanned it and I know a few things that I want to talk to you all about. So we'll start at the top. On January 4th, 2024, prior to resuming filming of It Ends With Us, following guild strikes, and a couple of things should jump out right now. This is the same place that the complaint in California started, and I commented on it in that first video of this series that this seemed odd. This is a strange in media res opening on January 4th, 2024, prior to resuming filming. Suggests that filming has already occurred. In fact, it had already occurred in 2023. That's usually where you would start this story, because we're also going to talk in this lawsuit about things that you are alleging to have happened during that period. but this is a storytelling document, just like the California complaint. And one of the stories that they want to tell is that this meeting happened after all these bad things happened, and everybody agreed that these bad things happened, that they would take steps to prevent them. On January 4th, prior to resuming filming, we had a meeting. The meeting included Justin Baldoni, Jamie Heath, the chief executive officer of Wayfarer, Angie Janetti, the film's representative for Sony, Alex Sachs, a producer, Todd Black, a producer, and Ms. Lively, who played the role of Lily Bloom in the film. Ms. Lively also had the agreed upon right to have a representative present. She chose her husband, given that the meeting was about repeated sexual harassment and other disturbing behavior by Mr. Baldani and Mr. Heath. And I've seen others talk about this. One of the things that I've said as part of this video series that I would like to reiterate here, just so nobody gets the wrong idea, is that I have long had kind of a bad impression of Ryan Reynolds, Blake Lively's husband, from afar. Deadpool, if you're not familiar with the name. And I have these bad vibes, essentially, from interviews, not so much in substance, but in tone. And so I try to label that in these videos so that you know that my instinct is to feel negatively about this. On the other hand, I think that we can talk about it kind of on a more objective basis, which is to say, in this context where you're going to be alleging sexual harassment and other disturbing behavior, I'm not positive that your acting husband is the right representative for you to have in this particular meeting. Now, that's hindsight bias, right? Part of what's happening here is that Ryan Reynolds is going to get caught up in all these allegations and this conversation. But I would say that it is the first thing that jumps out at me as part of this fact pattern. And it's the same fact pattern we saw in the California complaint. And whether or not he should be in the room is going to be part of this conversation. As discussed in detail below, Ms. Lively was forced to address concerns about Mr. Baldani and Mr. Heath's misconduct with them directly, and began doing so months before filming began. And now this is entirely unclear because we say January 4th is when this meeting happens for filming to continue in 2024. But when you say before filming began, this movie had already filmed a bunch of stuff. Do you mean before the movie filming began in its entirety? Before filming began after the strikes? I'm unclear here. And in a document like this, we want to be as clear as possible. And I'm going to try not to repeat my comments that I made to the California complaint because this is largely the same setup. During the January 4th meeting, the parties discussed in detail the inappropriate conduct that Ms. Lively, her employees, and other cast and crew experienced at the hands of Mr. Baldani and Mr. Heath. After the list below was reviewed and discussed in its entirety, all parties present agreed that the outlined conduct would cease. And again, this is the list we talked about before. This is things like no more showing nude videos or images of women, no more mention of pornography addiction, no more discussions about personal experiences with sex, etc., all of which are written with that no more context as if they have happened. And in this context, as presented in this complaint, as if everybody has agreed that they had in fact happened. When we know from Baldani's lawsuit that this list, at least according to his perspective, was essentially one where he didn't want to fight the language used on the no more, but that the things that they were actually asking to be done in the side letter and what have you were things that they would want to do to make a safe working environment anyway. So we're in a full reasonable minds can differ, he said, she said kind of setup, but at the very top of the document, the introduction, where you're presenting your strongest part of the case, this happened. All parties present agreed that the outlined conduct would cease. That sounds to any normal human being like that's an admittance that this happened and we would stop it. But in lawyer land, this doesn't mean that, right? This means that this will not happen, but we're not otherwise acceding to the way that you've described it. And there's a difference there, even if it might seem like angels on the head of a pin. This meeting was an essential step in a process the parties had agreed to several months before to allow the cast and crew to safely resume production of the film. In mid-November 2023, now that we're already odd, right? The timeline's going backwards now. We started in January 2024. In mid-November 2023, the parties had agreed in writing to implement a list of protections enumerated in a contract entitled Protections for Return to Production, attached as Exhibit A, which included 17 provisions designed to require Wayfarer to cease the on-set behavior of Mr. Baldani and Mr. Heath. One of these provisions required an all-hands meeting to confirm and approve a plan for the implementation of certain protections that will be adhered to for the physical and emotional safety of Ms. Lively, her employees, and all cast and crew moving forward. After receiving the document, Wayfarer responded that Wayfarer, Sony, and production respectfully acknowledge that Ms. Lively has concerns regarding safety, professionalism, and workplace culture. Although our perspective differs in many aspects, ensuring a safe environment for all is paramount, irrespective of differing viewpoints. Regarding your outline requests, we find most of them not only reasonable, but also essential for the benefit of all parties involved. And again, this is put here in this document to suggest that they have acceded to this list here that we don't otherwise have kind of a notion of origin. We know that the Baldani lawsuit says this was essentially an email circulated. We don't know the context here. That's not their job as lawyers for Team Lively to give us that context necessarily, but we do want to be as truthful and as accurate as possible when filing court documents, even more so than filing documents with a commission in the state of California. And so it's a little bit off-putting to see so little context here for what we know is a disputed set of facts. And it's good that they admit that this quote is essentially the Wayfarer team saying, we don't agree with the way that you've described these things, but we agree with the solutions that we can handle here, that these are all reasonable. At the end of that meeting, having discussed at length the details of concerns that had been expressed by Lively and others, the parties agreed to implement and follow the protections for return to production to ensure that the film could be completed, marketed, and released safely and successfully, and it was. Production of the film resumed on January 5th and concluded on February 9th, 2024. The film has been a resounding success. And that's a part of this story as well, one that I really didn't harp on the first video, but one of the things that this is saying is we had these complaints, there were these very bad things, but that the studio effectively fixed them up, right? That we got them fixed, they agreed to the protections, and then the film was concluded and released successfully. Leading up to and in connection with the release of the film during the summer of 2024, Ms. Lively and fellow cast members promoted the film in accordance with the marketing plan delivered by the film's distributor, Sony, which is summarized in the talking points on Exhibit C. This is where we know that they said be positive, talk about florals, etc. Ms. Lively and other cast members were under a contractual obligation to engage in media, press, marketing activities, and render promotional services in accordance with the marketing plan. The marketing plan directed the cast to focus more on Lily's strength and resilience, as opposed to describing the film as a story about domestic violence, and avoid talking about this film that makes it feel sad or heavy. It's a story of hope. And this is being used to present a counterpoint to what Baldani will wind up talking about with respect to this movie, and that they were contractually obligated to follow the Sony paradigm. But one thing that's happening here is that it's normal for anybody that's running a marketing op to say, be positive about our product, be positive about our service, don't harp on what might be seen as gloomy or negative. And there are ways to do that that can be successful, and there are ways to do that that can be seen as tone deaf. And one thing in reality that appears to have happened here is that Blake Lively and friends, however you want to frame this, were not so good at walking that line, that there were legitimate grievances that were posted about her being tone deaf, marketing her liquor brand and saying bring your florals, and harping on the hope and resilience, perhaps to the detriment of the serious topics that were at issue in the film. And again, different people can see different things from different perspectives here, but to the extent that you aren't connecting with your prospective audience for this movie, that audience is totally in line to say, I feel put off by the way you're marketing this film. Now, does that mean that it's impossible for Baldani or his PR reps to have floated things a little bit more and had catty messages added to these things to encourage negative response? No, it's not impossible at all. But there's also a way to see this as a potentially organic output of Blake Lively's attempts to market the movie, which is essentially what Baldani's lawyer says in that kind of fiery, this was organic, this was a result of her bad marketing, etc., etc. In the days leading up to the film's release, Mr. Baldani abruptly pivoted away from the film's marketing plan and the types of publicity activities in which he had previously participated. What the public did not know was that Mr. Baldani and his team did so in an effort to explain why many of the film's cast and crew had unfollowed Mr. Baldani on social media and were not appearing with him in public. To that end, he and his team used domestic violence survivor content to protect his public image, as described in further detail below. And if all of this is sounding a little bit like deja vu, that's because all of these paragraphs are basically directly from the complaint document that the New York Times reporting was based on, right? So we looked at that article. It's got a little bit more strange graphic presentation in the headline here. But in that complaint, we see the exact same setup. Starting with January 4th, address concerns. Here's the email list of various things. Same language used to talk about exactly how that list was agreed to or not. Same quote from Wayfarer leading up to and in connection. We had a marketing plan that we were obligated to follow. Mr. Baldani switched from that marketing plan and leading us back to here. So I don't want to waste your time. I don't want to just copy what we're talking about on these things, but I think it's important to get the context of what happened here, which is to say that the California complaint really was a predecessor to the lawsuit insofar as that Team Lively was paying the lawyers to draft what would be a lawsuit eventually, and then put it to a California complaint, even though it appears, since there was nothing stopping them from doing so, that they never intended to file that lawsuit in California. Understand also that part of the process in California is this: you have to go ask for an investigation and file that complaint document, but you can also say, I just want to go straight to a right to sue letter, and it doesn't appear that they did that in California because they're suing in federal court in the state of New York. What the public also did not know was that this was the beginning of a multi-tiered plan that Mr. Baldani and his team described as social manipulation designed to destroy Ms. Lively's reputation. That plan was backed by virtually unlimited resources. Wayfarer's co-founder, co-chairman, and leading financier is multi-billionaire Steve Sarowitz, who divulged at the film's New York premiere on August 6, 2024, that he was prepared to spend $100 million to ruin the lives of Ms. Lively and her family. With that backing, Mr. Baldani and his Wayfarer associates embarked on a sophisticated press and digital plan in retaliation for Ms. Lively exercising her legally protected right to speak up about their misconduct on the set. Now, spoiler alert, we're going to get to the counts and legal complaints here at the end of this document. That's where they go in a lawsuit filed like this one. But what's important to know here is that retaliation as a concept can really only be used in the laws that she's quoting here in this lawsuit if there is an underlying offense in the first instance. So she basically has to prove all of this as part of her lawsuit, and most especially that there was sexual harassment and that the campaign against her was a direct response to her reporting that harassment either to themselves or to in an attempt to notify the state of California of these particular issues. So there are a number of problems with this particular approach. There were problems even in the complaint document, whether this is retaliation or not. We're going to talk about those as part of this video, but you want to keep in mind that even though this is a little bit out of order, that they start with the best thing narratively for them, which is that everybody agreed to this list of bad things to no more happen, that she has to show that those bad things did happen. She has to show that she reported those bad things and that negative employment things were done to her as a response, that was retaliatory to that reporting and those bad things that happened. And I think we're going to see a certain amount of softness in the evidence here, especially on that last piece. And especially because, as far as I know, there isn't any precedent that suggests that a social media campaign is an adverse employment action. When we talk about adverse employment actions, and I'll bring up some legal documents as part of this video to talk about them with you more fulsomely, we are really talking about firing, we're really talking about demotion, or in a broader spectrum, we're talking about not letting the employee go to important lunches, not having access to certain rooms, whatever it might be. Something within the context of employment that is negative for their ability to succeed in that employment environment. Not so much in this particular situation where the employment has effectively ceased. Like, we don't need Blake Lively to film anything more for the movie. And then there might be a retaliation campaign. There might be a negative social media campaign engaged in by Baldani and his PR. Is that an adverse employment action for purposes of Civil Rights Act, which we will see quoted here in this lawsuit? Is that an adverse employment action in connection with California law, which we'll also see quoted, which can be used in any jurisdiction in the federal court system, as long as they refer back to California precedents? We'll see all that when we get there, but it's a question to keep in mind as to whether or not this actually meets the requirements of the law, even if it's a very bad thing, right? And we say here all the time that not everything that is right is legal. Not everything that is bad is illegal. On July 31st, 2024, following the recommendation of their publicist, Jennifer Abel, Wayfarer and Mr. Baldani retained a crisis communication specialist named Melissa Nathan and her company, the agency group, which we're going to call TAG. Ms. Nathan delivered a proposal to Mr. Baldani, which included a website to discuss, full Reddit, full social account takedowns, full social crisis team on hand for anything, engage with audiences in the right way, start threads of theories, discuss. This is the way to be fully 100% protected. Essentially, a set of notes for what they would do as a social media consultant. Ms. Nathan also proposed this creation of social fan engagement to go back and forth with any negative accounts, helping to change the narrative and stay on track. All of this will be most importantly untraceable. As Ms. Abel described it, the plan was to engage in social media mitigation and proactive fan posting to counter the negative, as well as social manipulation. All these very bad words might be bad from an ethical standpoint, might be bad from the way you think about these things, not directly understood to be illegal, right? We don't have a lot of good laws on the books for social media manipulation, whatever that might mean. In this context, we do have defamation. We do have false light concerns that we have seen in the Baldani lawsuit, and we will eventually see in the Baldani lawsuit against Lively. And I think we'll see here, but it's not at all clear what they are describing here, other than trying to make you feel bad about what they might do, is necessarily illegal. And I think a lot of people have a negative reaction to what PR folks or crisis communication managers do, right? Their job in some important respect is to manipulate, right? Is to change the outward perception of what is happening on an internal basis. To be so good at drafting press releases, so good at communicating with the prospective audience for something, that they can change the very narrative on which those people are interacting with that product or service. And I think that feels bad to people. And I think that's justifiable to feel bad about. I think it's a job that involves a certain amount of, if not outright deception, as I said, manipulation. And so they're using that in this bit of documentation to suggest that Nathan and Tag and ultimately Abel and Wayfarer are very bad people for doing this. But it's entirely unclear to me as I read this and I read it again that this is actually illegal in fact. This plan went well beyond standard crisis PR. What Ms. Nathan proposed included a practice known as astroturfing, which has been defined as the practice of publishing opinions or comments on the internet, in the media, etc., that appear to come from ordinary members of the public, but actually come from a particular company or political group. And there can be things like false advertising there. There can be violations of terms of service for these various sites that you might post on, but it's not outwardly, other than a civil infraction or a breach of contract or that kind of thing, an obvious criminal or other offense. On August 2nd, 2024, TAG circulated a scenario planning document. Should Ms. Lively and her team make her grievances public? To get ahead of the narrative, Ms. Nathan proposed strategies to advance misleading counter-narratives, including pushing Ms. Nathan's narrative that Ms. Lively had less than favorable reputation, proposing to explore planting stories about the weaponization of feminism, and misleadingly blaming Ms. Lively for production members' job losses. Which might be untrue, we don't really know, but certainly putting other information out there that is not great for your client, not known to be illegal in most circumstances. Initially, Mr. Baldani expressed concerns that TAG's written plan was insufficiently aggressive to protect him. Writing to Mr. Heath and Ms. Abel, he said he was not in love with the document they sent. Not sure I'm feeling the protection I felt on the call with Ms. Nathan and her colleagues. In response, Mr. Heath attempted to reassure Mr. Baldani that they had found the right people for his campaign. In Mr. Heath's words, the most important part of this is how quickly they can shut things down and place stories in your favor. Again, with this story, we've seen all this before, but it's all just negative vibes, right? For the most part right now, it's all negative vibes. Later that day, Ms. Abel and Ms. Nathan exchanged the following text messages expressing that Mr. Baldani wants to feel like Ms. Lively can be buried. Ms. Abel and Ms. Nathan agreed that, of course, they would do just that, but could not say so in writing. We can't write it down to him. We can't write, we will destroy her. Imagine if a document saying all the things that he wants ends up in the wrong hands. Ms. Nathan followed this by assuring Ms. Abel, you know we can bury anyone, but I can't write that to him. A few days later, on August 5th, 2024, Mr. Baldani set the narrative for the social media campaign, sending Ms. Abel a screenshot of a thread on X that had accused another female celebrity of bullying women. Mr. Baldani stated, this is what we would need. We've seen all this already. We're going to scroll forward a little bit more. This is exactly what's in the California complaint. So if you want to see that discussed a little bit more completely, you can check out the first video of this playlist, which I have entitled It Ends with Lawsuits, because I like puns. But I want to get to the parties, the jurisdiction, and ultimately the counts here, the complaints on a legal basis. So the parties are Lively, Wayfarer, Baldani, and Sarowitz. It ends with Us Movie LLC, which we talked about as part of that first video, being a subsidiary entity where you go and you put your specific liabilities and issues that you might have with the making of a specific movie or film in a different entity so as to protect whatever other things might happen on a different movie in this particular case, or if you're a real estate developer on a different property. And that's a very normal structural thing to do. There's nothing untoward about that. Defendant Melissa Nathan, we already know, is the TAG Group outside crisis communications PR consultant. And then defendant Jennifer Abel is an important part of the story. She's essentially internal to Wayfarer. She has her own small shop, and she appears to be the genesis point of where all these text messages are coming from, right? We saw the Baldani lawsuit kind of talk about this a little bit. We're not going to be able to get into this because I don't want to defocus this conversation so much, but it's an important part of the story to note that, as TMZ says here in very understated tones, Justin Baldoni, ex-publicist, sues his crisis PR team. They tried to take me down too. And in that particular lawsuit, as reported on by the New York Times, let's see if we can get that, Justin Baldoni's ex-publicist sues over alleged smear campaign. And this is reported on by Megan Twohey and Mike McIntyre. A former publicist for the actor and director Justin Baldoni filed a lawsuit on Tuesday that adds a new dimension to an alleged campaign to undermine the actress Blake Lively. The publicist, Stephanie Jones, said she was forced out of representing Mr. Baldoni and his film studio amid concerns that Ms. Lively would go public with accusations of misconduct against him. So, to put this in context, Stephanie Jones, Ms. Jones, is reported here by the New York Times, was working as a PR person. One of her clients was Wayfarer Studios and Justin Baldoni. She had assigned Jennifer Abel essentially to the function of covering their PR needs. And then she's going to accuse Ms. Abel, who we see as part of this main lawsuit and the other lawsuits in Lively versus Baldoni directly, of stealing information from her company to start her own. And as part of that, the subpoena that we've talked about in a couple of different places seems to be the one that was covered here. Ms. Lively's legal complaint includes excerpts from thousands of pages of text messages and emails that she had obtained through a subpoena. Ms. Jones's lawsuit reveals that those messages came from a company phone used by one of her former employees, Jennifer Abel, who was among those Ms. Lively accused of helping to orchestrate a smear campaign against her. Ms. Jones said she fired Ms. Abel last summer after discovering that Ms. Abel had been stealing documents from her firm as she prepared to start her own business. And again, this is the New York Times reporting on a different legal complaint than the one we were talking about at the start. But it is also important to note that this is just reporting on allegations. This is just what Stephanie Jones is accusing Jennifer Abel of in this context. But what's also important is that these text messages become available by virtue of the subpoena. And this is one of the things that Team Baldani has said was essentially a way for Stephanie Jones to avoid the non-disclosure agreement that she would have entered into with her clients, Wayfarer and Justin Baldoni, to get this information in the hands of Blake Lively and her team. That doesn't have to be the case. That's Baldani's accusation against Jones. Jones would undoubtedly say that that is not what happened, but there is a complicated network, a spider web of competing interests and situations here that are all happening. And Stephanie Jones appears to have essentially sided with Blake Lively and Ryan Reynolds for whatever her future PR business is. And that's a part of this story as well. Ms. Jones says in the lawsuit that in reviewing the messages, she discovered that her former employee had been involved in a retaliation campaign against Ms. Lively. At bare minimum, if that is in fact the case, it sounds like a very poor supervisor that is letting her person run around, steal company documents, and engage in legal liability type campaigns without her knowledge. So if I were Stephanie Jones in this particular context in this lawsuit, I would at least be aware that it makes me look like a very bad boss and potentially a very bad professional in terms of the people that I might put on your file. That doesn't appear to be the case here. She appears to have selected her side in this fight, and that's on Blake Lively's side, and that's totally fine. But that's all happening behind the scenes here. I had thought about doing a video where we talked about this lawsuit. I didn't find too much of excitement there. I thought the New York Times covered it and the allegations just fine. But I did want to raise that as part of this conversation because that is happening behind the scenes, that Jennifer Abel is not just another body on this lawsuit. She is, in fact, apparently the source of much of the information, not at her voluntary discretion, but a source of the information that Blake Lively and her team are using as part of this lawsuit and as part of the California complaint that kicked all this off. The court has original jurisdiction over the claims for relief asserted in this complaint pursuant to these various statutes, but suffice to say the federal court has most jurisdiction over civil complaints like this, especially when there is what we know as diversity of location. Plaintiff's Title VII causes of action arise under federal law, and plaintiff's California claims arise from the same underlying facts, so they can be related in this case. And the court has jurisdiction because the claims for relief asserted in this complaint in controversy exceeds the sum of $75,000, and no defendant is a citizen of the same state as plaintiff. Right, so this is called diversity jurisdiction. It has nothing to do with other diversity you might hear about on other YouTube channels or in social media. It means that you've got citizens from two different states arguing about something substantial. In this case, $75,000 or more, and it's a lot more, as we will see. And that means that the federal courts can look at it. That's important to understand because it does mean, this is all true, that Justin Baldoni could have sued in federal court as well. And federal court doesn't have an anti-SLAPP statute. Federal court doesn't have the same issues that California does. And that's one of the reasons I raised that in that prior video, because it didn't make a ton of sense if you wanted your lawsuit to have the best possible chance of success. That lawsuit against the New York Times appears to be a bit of a red herring insofar as it doesn't seem to have much of a chance of success of even making it out of the first stage of any kind of court situation, but was used primarily to get reporting done on the opposite side of the original New York Times article that was reporting on Lively's complaint. You can feel however you want about that, but it's important to understand that the context of this is that we are really watching a highly resourced, well-leveraged PR war using our court system, and that comes from both sides. We can talk about the underlying facts. We're not going to get into too much of the supposition or guesswork being done on social media about what various videos and screenshots and audio clips mean. I know those are floating out there. We might cover them later in the series. We might not. I'm really more interested in the legal process and the legal documents here. But however you feel about who is in the right on the he said, she said component of this story, it's important to understand that both are using New York Times leaks and the court system to try to get their message out there to try to determine a win in the court of public opinion. That's part of this story. It can't be avoided. Continuing on, we get to the factual allegations. And this was a section that we really didn't talk about in too much depth in that first video because I found it to be largely repetitive from the introduction. So we're going to try to cover a few more aspects of it here, understanding first and foremost that these are allegations by Blake Lively and her team in this document. They are not otherwise proved at this moment in time. This is just a complaint. This is just a lawsuit and one person's side of the story. But that if we assume it to be true, there are various aspects that we can talk about as being problematic for operating in a good working environment. So she starts by talking about Baldani and Jamie Heath of Wayfarer and how they engaged in inappropriate and unwelcome behavior towards Lively and others on set. Mr. Baldani launched Wayfarer in 2020. Mr. Heath serves as Wayfarer's chief executive officer. Mr. Sarowitz is a leading financier of Wayfarer, and he, Mr. Heath, and Mr. Baldani are all close personal friends. Under the Wayfarer banner, Mr. Baldani and Mr. Heath have many platforms, including the Man Enough podcast, which they will definitely talk about as part of this lawsuit, which they co-host. Mr. Baldani and Mr. Heath have positioned Wayfarer as a male feminist platform that explores gender roles, dismantles toxic masculinity, and creates a safer and judgment-free society for women. And this reference included here in paragraph 42 suggests to me that they are trying to establish this is essentially a wolf in sheep's clothing kind of setup. Mr. Baldani serves not only as the co-founder and co-chairman of the studio that financed and ran production on It Ends With Us, he also served as director, executive producer, and co-lead actor, playing the role of Ryle Kincaid. As studio head and director, all actors, crew, and staff on the film, including Ms. Lively, answered to Mr. Baldani. In his words, he was the leader who sat at the top of this totem pole. While Sony was the distributor releasing the film, Wayfarer was responsible for the production, and Wayfarer was led by Mr. Baldani and Mr. Heath. Notably, Sony, not included in the defendants here, Sony is largely getting out of this legal dispute unscathed. Production of the film began in early May 2023 and lasted until it was suspended in mid-June 2023 due to the Writers Guild of America strike. And importantly, remember when we talked about the introduction starting in January 2024, this was actual production of the film started in mid-2023. During that time in mid-2023, which is only about a month, Ms. Lively and other cast and crew experienced invasive, unwelcome, unprofessional, and sexually inappropriate behavior by Mr. Baldani and Mr. Heath. Because Mr. Baldani and Mr. Heath held all leadership positions on the production, they answered to no one and brushed off or ignored the concerns Ms. Lively and others expressed. Now, notably here, there is a certain obligation to try to proceed through normal channels if you're going to claim retaliation or bad acts on the part of a employer. And they appear to be eliding that a little bit in this complaint document by saying, look, it was all the same people in all steps of this particular employment situation, so there was no point to go to them because they were not going to investigate themselves. And that's fine. That's fair. You can maybe get some leeway with that in a court of law, but it is not the normal, strongest set of facts that you would like to have if you are proceeding along a harassment and retaliation kind of campaign. Mr. Baldani ignored well-established industry protocols in filming intimate scenes and exploited the lack of controls on set to behave inappropriately. Wayfarer failed to adhere to guild rules as well as Ms. Lively's contract and standard industry safety protocols with respect to nudity and intimate scenes, which the Screen Actors Guild and the American Federation of Television and Radio Artists, I don't think I ever knew what AFTRA was in SAG-AFTRA, so that's nice, acknowledges places performers in uniquely vulnerable situations. Such safeguards ignored by Wayfarer include providing performers with appropriate notice of nudity and simulated sex and ensuring that 1, consent is given free of pressure or coercion, 2, signed nudity riders are in place spelling out the parameters of nudity or simulated sex scenes, 3, safe and secure working conditions that are not detrimental to a performer's health, safety, morals, and career, and 4, the use of intimacy coordinators to observe intimate scenes. And understand, as they will in all of these various paragraphs, that Baldani in his lawsuit and his team in public statements and otherwise have largely rejected this description of events. This is the Lively version of events. We have to understand that it is contested on the ground in various ways by the other side. But we also have to note that even in the absence of guild rules, failing to adhere to guild rules in various other ways is not in and of itself illegal in terms of creating a civil rights violation. You can have breach of contract, absolutely. You can have breach of the rules that have you making movies within the guild system. You can have all these various things. That doesn't necessarily mean that you have a civil rights violation, which is what we're going to talk about here. Without these protections in place, Mr. Baldani improvised physical intimacy that had not been rehearsed, choreographed, or discussed with Ms. Lively, with no intimacy coordinator involved. And Baldani says that the intimacy coordinator, he tried to coordinate with Lively and she didn't want to meet with him. And so he did all this with the intimacy coordinator and then essentially relayed it to Ms. Lively on set. That may or may not float your boat in terms of an understanding of what happened here. But that's his story. For instance, Mr. Baldani discreetly bit and sucked on Ms. Lively's lower lip during a scene in which he improvised numerous kisses on each take. Mr. Baldani insisted on shooting the full scene over and over again, well beyond what would have been required on an ordinary set and without advance notice or consent. On another occasion, Mr. Baldani and Ms. Lively were filming a slow dance scene for a montage in which no sound was recorded. Mr. Baldani chose to let the camera roll and have them perform the scene, but did not act in character as Ryle. Instead, he spoke to Ms. Lively out of character as himself. And we'll see a screenshot of that later on in this video. I want to talk about it a little bit. At one point, he leaned forward and slowly dragged his lips from her ear and down her neck as he said, "It smells so good." None of this was remotely in character or based on any dialogue in the script, and nothing needed to be said again. There was no sound. Mr. Baldani was caressing Mr. Lively with his mouth in a way that had nothing to do with their roles. When Ms. Lively later objected to this behavior, Mr. Baldani's response was, "I'm not even attracted to you." So we've got one story here of essentially overuse of innuendo in a scene that doesn't have sound and would be recorded in slow motion. Mr. Baldani inserted improvised gratuitous sexual content and or scenes involving nudity into the film, including for an underage character, in highly unsettling ways. After Ms. Lively signed on to the movie based on the draft for the script, Mr. Baldani, without Ms. Lively's knowledge or consent, personally added graphic content, including a scene in which Ms. Lively was to orgasm on camera. When Ms. Lively objected to these additions, Mr. Baldani insisted he added them because he was making the film through the female gaze. Although he agreed to remove the scenes, he made a last-ditch attempt to keep one. We talked about this a little bit in the first video. A lot of stuff I would prefer YouTube to not have to ding me on the content of my channel. On the day of shooting, the scene in which Ms. Lively's character gives birth, Mr. Baldani and Mr. Heath suddenly pressured Ms. Lively to simulate full nudity, despite no mention of nudity for the scene. Mr. Baldani insisted to Ms. Lively that women give birth naked and that his wife had ripped her clothes off during labor. He claimed it was not normal for women to remain in their hospital gowns while giving birth. That was not my experience, for what it's worth. Ms. Lively disagreed, but felt forced into a compromise that she would be naked from below the chest down. When the birth scene was filmed, the set was chaotic, crowded, and utterly lacking in standard industry protections for filming nude scenes, such as choreographing the scene with an intimacy coordinator, having a signed nudity writer, or simply turning off the monitors so the scene was not broadcast to all crew on set. Mr. Heath and Mr. Baldani also failed to close the set, allowing non-essential crew to pass through, while Ms. Lively was mostly nude with her legs spread wide in stirrups and only a small piece of fabric covering her genitalia. Among the non-essential persons present that day was Wayfarer co-chairman Mr. Sarowitz, who flew in for one of his set visits. Ms. Lively was not provided with anything to cover herself with between takes until after she had made multiple requests. Ms. Lively became even more alarmed when Mr. Baldani introduced his best friend to play the role of the OBGYN, when ordinarily a small role of this nature would be filled by a local actor. And I don't know enough about this particular context here about whether the best friend is an actor or not. But again, like so much of this particular complaint, it's all kind of left in the in-between the lines area, right? It's implied here that this best friend had no acting experience and was not otherwise capable of the role. But we don't know that for a fact. And based on what we do know about what's being skipped here, and at least what is contested in the Baldani lawsuits, we can assume that some of this is skipping facts that might be seen as not so useful to Team Lively. Ms. Lively felt that the selection of Mr. Baldani's friend for this intimate role, in which the actor's face and hands were in close proximity to her nearly nude genitalia for a birth scene, was invasive and humiliating. To add insult to injury, Mr. Heath approached Ms. Lively and her assistant on set and started playing a video of a fully nude woman with her legs spread apart. Ms. Lively thought he was showing her pornography and stopped him. And at least what we have floating around social media does not suggest a fully nude woman in that particular video. But Ms. Lively thought he was showing her pornography does not mean that he was. Mr. Heath explained that the video was his wife giving birth. Ms. Lively was alarmed and asked Mr. Heath if he knew his wife was sharing the video. Mr. Heath, if his wife knew he was sharing the video, to which he replied she isn't weird about this stuff, as if Ms. Lively was weird for not welcoming it. Mr. Baldani added a detailed scene to the film in which the underage version of Ms. Lively's character, Lily, loses her virginity. And that's clearly not Ms. Lively to the extent of it being an underage version of her character. In both the book and the script for the film, there was no sex scene. Instead, the details about this moment were left to the audience's imagination. But Mr. Baldani added in considerable details, including both dialogue between young Lily and her boyfriend, Atlas. I thought I was going to get through this one without commenting on the names in this book, but young Lily's boyfriend's name is Atlas. Okay. Apologies. I'll be right back reading the sentence in just a second. As well as a simulated sex scene in which Mr. Baldani filmed and included in his initial cut of the film a close-up of young Lily's face, accompanied by an audible gasp. Ms. Lively was informed that when the scene was shot, after Mr. Baldani called cut, he walked over to the actors and said, "I'm not supposed to say this, but that was hot. And did you two practice this before?" So I think the Team Lively is including this particular anecdote to indicate that it wasn't just her. It was just a generally hostile workplace environment. He was sexually harassing everybody. Mr. Baldani and Mr. Heath discussed their personal sexual experiences and previous porn addiction and tried to pressure Ms. Lively to reveal details about her intimate life. During a car ride with Ms. Lively, her assistant and driver, Mr. Baldani, claimed to Ms. Lively that he had been sexually abused by a former girlfriend, which he has since shared publicly. At the end of this story, typos happen even to lawyers, folks. Mr. Baldani shared that it had caused him to re-examine his past. He then said, "Did I always ask for consent? No. Did I always listen when they said no? No." Mr. Baldani claimed this was an example of how we all have things from which we can learn and grow. Ms. Lively was unsettled by Mr. Baldani's suggestion that he had engaged in sexual conduct without consent. They're trying to paint an overall picture of a man that is just talking about whatever he wants with his employees, whom he has power over. But most of these anecdotes, or at least this one in particular, it seems to be more of a bad vibes kind of guy thing than something that is directly harassing Blake Lively or otherwise. So to the extent that you're going to have issues, possibly, with other aspects of the evidence in this lawsuit, you're going to wind up having issues even more so with the stuff that is just stories of essentially being, as the lawyers might put it, skeeved out. On the first day of production, Mr. Baldani and Mr. Heath described their past sexual relationships to Ms. Lively, including that one of them used to hook up with a woman. Okay. Mr. Baldani said that he had decided the woman wasn't the one, so then Mr. Heath had gotten together with her. Ms. Lively found this description of passing along a woman to be disrespectful and disturbing. Yeah, it's not what you want to hear in your workplace. That is undoubtedly true. Mr. Baldani and Mr. Heath often spoke of their previous pornography addiction. Mr. Baldani engaged in other behaviors that were shocking and emotionally distressing. For example, he claimed he could speak to the dead, and on several occasions told her that he had spoken to her dead father. It was off-putting and violative for Mr. Baldani to claim a personal relationship with her recently deceased father. Again, bad vibes. Guy's a whack job. He is uncool. You don't want to work for this person. We should get damages. Mr. Baldani and Mr. Heath were also constantly hugging and touching cast and crew. When Ms. Lively or others avoided this touching, Mr. Baldani and Mr. Heath would retaliate by becoming irritated, cold, and uncollaborative. And here's an area where this use of language is probably important. Remember, this is a lawsuit about legal retaliation, or more specifically, illegal retaliation. When you start describing becoming irritated, cold, and uncollaborative to not getting a hug as retaliating, I start to become concerned that you're not using the word in the way that the law wants you to be using the word, right? Becoming irritated for not getting a hug, not retaliatory. Might just be the way that you feel. And again, I understand the picture that they are framing here, and certainly some of the stories, if as exactly as delivered by Ms. Lively, giving her the full benefit of the doubt here, would present a potentially hostile workplace environment. But I get concerned when you start saying he hugged everybody, and when he didn't get a hug from Ms. Lively, he became irritated, cold, and uncollaborative. First and foremost, if we're talking about harassment on the basis of sex, we can't say that he hugs everybody. That's not terribly useful unless you're going to isolate it to the women. But in this context, you say he doesn't get a hug and he is now retaliating by becoming cold. This doesn't work for me at all. Mr. Baldani objectified Ms. Lively and other women by commenting on or criticizing their bodies as sex objects. Mr. Baldani often referred to women in the workplace as sexy. When they expressed discomfort, Mr. Baldani would deflect or try to pass it off, which undermined Ms. Lively's and others' concerns. For example, on one occasion that Ms. Lively observed, he told a female cast member that her leather pants looked sexy when she arrived to the set. When she rebuffed his comment because she was uncomfortable rather than apologizing, he brushed it off with, "I can say that because my wife is here today." Ms. Lively felt embarrassed witnessing this kind of commentary, as did others. So again, light anecdote, still kind of going to building the foundation of this is a hostile workplace type environment, but not in and of itself terribly informative. On another day, Ms. Lively wore a low-cut dress to facilitate breastfeeding, but had it covered up with a coat. When the jacket briefly popped open at one point to reveal the dress, Mr. Baldani commented about how much he liked her outfit, which flustered Ms. Lively. Later that day, Mr. Baldani pressured Ms. Lively to remove her coat in front of the crew and multiple background actors in a packed bar. He said that he wanted to see her onesie under the coat because it was zipped low to reveal her lace bra. Consistent with past practice, he said, "I think you look sexy," in a tone that made her feel ogled and exposed. With other female cast members present, she said, "That's not what I'm going for." He bristled and replied, "I'm sorry, hot." Deeply uncomfortable, Ms. Lively said, "Not that either." Mr. Baldani responded sarcastically, "I guess I missed the HR meeting," and walked away. Now, first of all, this anecdote as described in this lawsuit does sound to me like the kind of thing that can happen in a workplace. I'm sorry to say that all checks out for how these kinds of interactions can go down. And certainly it's not something that I would recommend if I were to sit across the desk from you in a labor meeting. But it also maybe isn't necessarily enough to get you across the finish line for a hostile workplace environment, especially since there's descriptions of a bar and it being not at the work site or on work time necessarily. There's always things that seem to be elided a little bit here in this complaint. Another woman on the production spoke to Ms. Lively afterward to offer empathy and to share her own similar experiences with Mr. Baldani, commenting about her in sexual terms. And this guy might be a complete creep, right? This guy might be a complete creep who does, again, on a legal basis, skeeve you out and you don't want to work for, and may well be engaging in creating a hostile workplace and otherwise harassing. It's just we have to only take what's in front of us and try to figure out whether or not they're crossing the finish line at this point in this document. And we're still left with basically only the things that are in the California complaint. As a result of Mr. Baldani's behavior, on May 29th, 2023, another cast member lodged a sexual harassment complaint against Mr. Baldani's gross and unwanted comments towards her and others. While, on the other hand, Mr. Baldani was objectifying Ms. Lively as a sex object, on the one hand, he went out of his way to message criticisms of her age and weight, neither of which she could change during filming. On the second day of filming, for example, Mr. Baldani made the rest of the cast and crew wait for hours while he cried in Ms. Lively's dressing room, claiming social media commenters were saying that Ms. Lively looked old and unattractive based on paparazzi photos from the set. And we know from Baldani's lawsuit that his claim on this particular story is that she was picking out her own clothes and that his movie that he had put his time and effort into licensing and funding and making happen was potentially at risk because paparazzi were taking unflattering photos of Blake Lively, and he was sad about that. Again, not entirely clear who's in the right on that. I don't want to pick a side. It really is fully he said, she said on these kind of things. But realistically, both sides can sound correct here, and it's a little bit odd for Baldani to just be crying in her dressing room in the context of the way that it's described here. Ms. Lively tried to reassure him that she should look authentic in the scenes depicted in the photos, which were just after her character had been abused by her fictional husband rather than hot. Mr. Baldani, however, appeared focused on Ms. Lively's sexual appeal above all else. His lengthy outburst caused a delay in shooting, forcing an emotional scene to be shot haphazardly. And this is odd, right? This is essentially, he's so bad at his job that the actual production of the movie is getting impacted negatively. We know from the start, we know from the real history of things on the outside that the movie got done and was successful. So it doesn't make a lot of sense to me from a legal point of view to start essentially impugning his ability to actually make the film. But you're trying to drag in that not only was he harassing, not only was he creating a hostile workplace environment, he was also jeopardizing the actual product itself. And I don't know exactly what that does for you in this legal context, but you're, again, trying to make him look like a bad person in multiple different ways. To make matters worse, when Ms. Lively tried to have a meeting with Mr. Heath and the other producers to discuss Mr. Baldani's unprofessional behavior described above, that meeting turned into yet another violation. Rather than an ordinary meeting time and place, Mr. Heath arrived unannounced at Ms. Lively's hair and makeup trailer while she was topless and having body makeup removed by makeup artists. Ms. Lively told Mr. Heath that she was almost done and they could meet once she was clothed. Mr. Heath, however, insisted that if she did not allow him into her trailer to speak to him at that moment, then there would be no meeting with the other producers. Ms. Lively reluctantly agreed, but asked that Mr. Heath keep his back turned. A few minutes into the conversation, Ms. Lively noticed that Mr. Heath was staring directly at her while she was topless. When she called him out, Mr. Heath brushed it off as a habit of wanting to look at a person while speaking to them. Ms. Lively and her hair and makeup artist were all deeply disturbed by this interaction on just the second day of filming. Throughout filming, Mr. Baldani and Mr. Heath invaded Ms. Lively's privacy by entering her makeup trailer uninvited while she was undressed, including when she was breastfeeding her infant child. We know that Baldani says that they have a text message that says, you should come in while I'm pumping so that we can work on lines. I mentioned in the video where I was talking about that particular response that while that might work for at least one instance, you can still imagine a world in which approval in that one instance was not intended to mean approval for all other instances, and that it could have been essentially overused by Baldani and Heath and anyone else. And this is how you get into these situations where, yeah, there's probably some truth on both sides of these complaint documents. There's probably some truth on both sides of these lawsuits. There's certainly some truth in the PR fight being waged from both sides, because that's what you base your stuff on, is you have truth, you have that kernel of truth, and then you shade things to the advantage of your client in various different directions. Lawyers do that in legal documents like this one all the time. Richard Baldani also routinely degraded Ms. Lively by finding back-channel ways of criticizing her body and weight. So they have a difficult issue here to say that he's sexually harassing her and wants to nibble on her ear and say various things to her while also criticizing her all the time. But again, it doesn't matter so much when you're just trying to establish a foundation for this guy's a bad guy. A few weeks before filming began, and less than 4 months after Ms. Lively had given birth to her fourth child, Ms. Lively was humiliated to learn that Mr. Baldani secretly called her fitness trainer without her knowledge or permission and implied that he wanted her to lose weight in 2 weeks. Mr. Baldani told the trainer that he had asked because he was concerned about having to pick Ms. Lively up in a scene for the movie, but there was no such scene. And he does say that he was concerned about having to pick her up in a dance scene, I think. And the fact that there was no such scene is indicative of what wound up in the final cut of the movie. We know there's a fight about who even has the final cut of the movie, but whether one was filmed or not is a little bit unclear with respect to there was no such scene. Let's look at the footnote. In later text messages sent to his team, Mr. Baldani referred to Ms. Lively's trainer as a damn spy and sought to plant stories to portray his concerns as being motivated by his lower back pain. So he's a bad guy, and then he tried to manipulate this particular story. So there's essentially a response in advance to what they know is his response in his own lawsuit against the New York Times. When Ms. Lively caught strep throat, Mr. Baldani offered as a gift to connect her with an expert he had on retainer to help her with probiotics and to combat the sickness. When Ms. Lively went to fill out the privacy forms, she saw that the expert was not what Mr. Baldani had represented her to be, but was instead a weight loss specialist. Ms. Lively felt once again that Mr. Baldani was shaming her for her body and weight. And I do want to grab one member comment we have here before we move too far on and give my voice a little bit of a break here momentarily. So let me grab this before we do go on. Emily Aarons, I feel like all the filings on both sides are crisis PR because of the poor marketing of the film and his because of her first complaint. Oh, I definitely think there's a lot going on here where they're fighting amongst themselves on various aspects of what they're saying. The complaint being leaked to the New York Times and then being released gave Team Baldani the ability to know exactly what he was being accused of and frame his various legal documents in response to those. We know now, from what we can see in this lawsuit, that they were able to take his lawsuit against the New York Times and frame their responses a little bit more towards what they know to be his counter arguments for what's happening. So I do think that this is a situation where you have a PR fight. It's not specifically focused on the legal parameters of what's happening here, which can be frustrating to people like me or other lawyers you might see comment on this on YouTube or otherwise, because we usually see these things really aimed at what the constituent parts of an offense might be. In this case, we're looking specifically for instances of discrimination on the basis of sex. We're looking for areas of harassment, of making a hostile workplace, of otherwise taking negative employment action against someone on this basis. And when we start talking about, well, he was really upset about my weight, these various things, in a capacity for an actor that is going to need to be physically available in various ways in a movie filming, it maybe isn't as obvious a legal complaint as one that is designed to have quotes go out to the public and to be reported on by places like here, Hangouts and Headlines. So I hear you. I agree. Thank you for being a member for so long, Emily. I really appreciate it, and I really appreciate all the members of this channel and everybody that helps support it so much. Thank you so much. I am hopeful that that was an answer to your comment. Thank you for making it. Now, let's see if I can hit the right buttons to get back to talking about this document. Mr. Baldani and Mr. Heath also failed to implement COVID protocols when there was a COVID outbreak on set. Ms. Lively was told by another producer that because Wayfarer did not have insurance coverage for COVID, Mr. Baldani and Mr. Heath deliberately withheld from Ms. Lively that she had been exposed to COVID. Both Ms. Lively and her infant child contracted COVID from the outbreak on the set. Okay. Ms. Lively and others lodged grievances regarding the conduct of Mr. Baldani and Mr. Heath, which Wayfarer declines to investigate. Again, here, we heard earlier on that they were trying to set up that maybe they didn't go through all of the procedures to make a complaint here. But here they say that they didn't investigate the complaints that were made. As the studio producing the film, Wayfarer was the employer of all the cast and crew and was thus responsible for ensuring workplace safety. However, Wayfarer failed to provide Ms. Lively with even rudimentary employment protections, such as an employee handbook, sexual harassment policy, information, or any training on sexual harassment, discrimination, or respectful workplace expectations. Now, interestingly, if you're making this complaint, you're not so concerned that Blake Lively didn't receive training on sexual harassment. You're really more concerned that Justin Baldoni or Heath didn't receive training on sexual harassment, discrimination, or respectful workplace expectations. But again, these are kind of best practices for running a labor law consistent, compliant employer. They aren't necessarily requirements under the laws. You have to treat everybody fairly. You have to avoid having a discriminatory environment. That's one of the reasons why labor lawyers and lawyers in general like to have all these things in place, but they aren't strictly requirements. Wayfarer also failed to provide Ms. Lively with information about the process and procedure for filing human resources complaints. Certainly in this situation, that's something that you would want her to have the information about. As the producer and owner of the film, Wayfarer was legally obligated to address HR-related concerns or complaints. To Ms. Lively's knowledge, however, Wayfarer lacked any process for responding to complaints about its leadership, Mr. Baldani and Mr. Heath, who plainly were not going to investigate themselves. So note the headline is they lodge grievances and Wayfarer declines to investigate. But the first 4 paragraphs or so that we have here is essentially weren't given a process, there was no process, and they clearly weren't going to investigate. So we seem to have skipped a beat where you actually make the complaints and then they don't investigate. We'll see if we get there as we proceed on. On May 26, 2023, Ms. Lively told a representative of Sony that she wanted to file an HR complaint about both Mr. Baldani and Mr. Heath's misconduct. The Sony representative told Ms. Lively that Sony, as a distributor of the film, was not empowered to control Mr. Baldani or Mr. Heath's behavior on set, and that such concerns must be raised with Wayfarer, the studio responsible for the production. Wayfarer, Mr. Baldani, and Mr. Heath received or were aware of a number of HR grievances regarding their conduct. What does "were aware of" mean in this context, right? These are the questions that you ask from a legal perspective. Okay, they received grievances. You just said that there wasn't a procedure for the receipt of grievances. So what mechanism got them those grievances? And if there was a mechanism, why didn't you use it? And then if they were aware of grievances, what does that mean? I don't know whether that's journal entries. I don't know whether that's skywriting. I don't know what you're talking about with respect to that. Whispers on set, probably not good enough for a formal grievance process. Again, a well-compliant employer would have an employee handbook, would have a process, would have a procedure so that this doesn't happen. I have no problem saying that if they don't have those things in place, they are not minimizing their potential for legal liability. I also have no problem guessing or assuming that a lot of movie studios and a lot of independent movie studios in particular maybe don't go through dotting all the I's and crossing all the T's to maximize legal compliance or protection for themselves. For example, on the first day of filming, while attempting to hug Ms. Lively's employee, Mr. Heath said, "I don't even know if we're allowed to do this. It's day one and we have an HR report already." Right. That doesn't suggest that they're aware of HR grievances. That suggests that this guy is making a joke about HR and what you can and can't do in employment contexts. I know, Mr. Lawyer, that you have been in enterprises and employer contexts before. If you work at a law firm, you're familiar with this kind of joke. And so that doesn't make it right. That doesn't make it good. It also doesn't make it evidence of the first sentence of what you're trying to establish here, that they are aware of grievances. Additionally, even in the production, another actress made a complaint about Mr. Baldani's comments on her appearance. Mr. Baldani expressly acknowledged her concerns in writing, stating adjustments will be made accordingly. Yet on June 8th, 2023, that actress informed Ms. Lively that outside of anything in a scene, I actually cannot talk to Justin at all. Again, we're skipping steps here, right? We're trying to establish that they knew that there were HR problems and they didn't investigate them. We don't actually have a formal grievance here. We have made a complaint about Mr. Baldani's comments on her appearance, and he responded in writing. We don't know what corrections were taken, if any. We just have a statement from that actress that says, I can't talk to Justin. That doesn't really indicate much of anything about this. Mr. Baldani later expressed suspicion regarding Ms. Lively's friendship with this actress, as if they were colluding against him. Again, we're getting into areas of this particular legal document, and this is the same as the California complaint, where it starts to talk a little bit more like a gossip rag, right? It starts to talk a little bit more like a Daily Mail article or something else that you might otherwise complain about, that TMZ headline that we looked about with respect to the Stephanie Jones lawsuit. As described above, Ms. Lively and others attempted to raise concerns to Mr. Baldani and Mr. Heath regarding certain of the conduct described during filming, but they were not addressed given the futility of asking Mr. Baldani and Mr. Heath to address their own behavior. You keep emphasizing that they were never going to investigate themselves, they were never going to do anything. You keep saying that you raised concerns, you keep saying that they knew of grievances, but this still sounds like whispers on set. This still sounds like complaints in hair and makeup more than anything formal. I can totally empathize. I can sympathize with the notion that this company doesn't have a formal process and you feel like there's no one to turn to. Sony says that they won't take your complaints, but I don't think that actually means that you tried. And I'm having trouble finding that evidence in these particular paragraphs of your allegation. After unsuccessfully attempting to raise concerns with Sony, Ms. Lively expressly told Mr. Baldani and Mr. Heath that there were serious HR problems on set. Great. Well, I don't know how else you would tell except for expressly, but that's good. Mr. Heath responded that they knew, implying that someone had mentioned to them that Ms. Lively had raised concerns. In response, Mr. Heath told Ms. Lively that he thought she had wanted to see the nude video of his wife. It's an odd response. It's an odd paragraph, right? What do you mean that you knew of serious HR problems? What does it mean that you knew that someone had raised concerns? Why in the world would you respond that you thought that Ms. Lively had wanted to see a nude video of your wife? In the same conversation, when Ms. Lively expressed her upset, strange construction, that Mr. Heath and Mr. Baldani had hidden the fact that she had been exposed to a COVID outbreak on set from her, which she and her infant contracted COVID, instead of acknowledging responsibility and committing to safety moving forward, they expressed upset over production days missed and resulting costs. Despite receiving multiple detailed reports by Ms. Lively and others about Mr. Baldani and Mr. Heath's misconduct, When were those made? Why would you not mention those early in your fact pattern? Why would you not say, I made these multiple detailed reports? Wayfarer failed to investigate those reports or to otherwise institute protections for the cast. This is so even though the incidents discussed above, among others, did not take place in isolation, and many, if not all, were witnessed by others. Understand also that the way that this lawsuit is written is suggestive of the fact that when we had a meeting in January of 2024 and we put this letter together and we agreed to protections for the continuance of filming, that Wayfarer agreed. They might not have agreed with the way we framed it. They might not have agreed that everything had happened that way. But they agreed to take those protections immediately. Like, that's the first thing that you tell us in your lawsuit. So now you're asking us 80 some odd paragraphs later to say, oh yes, we made all these reports. We did all these various things that we can't actually describe for you in this section, but they refuse to investigate themselves. By these and other behaviors, Mr. Baldani, Mr. Heath, and Wayfarer engaged in harassing conduct and failed their obligations to investigate complaints of workplace harassment, prevent inappropriate and harassing behaviors on set, and provide avenues for cast and crew members to safely raise concerns to neutral parties so that they could be investigated and appropriately addressed. And understand why this is here from a liability perspective. So I'm going to talk like a lawyer here for a second, legal process and all. They need to go find money. They're trying to bring a lawsuit here for the reason of penalizing someone. Justin Baldoni, Jamie Heath, might not have that money. We don't know their particular financial situation. We do know that Wayfarer Studios probably has more money than the individuals. We know that it's funded to the tune of hundreds of millions of dollars, at least as described in this lawsuit. So you want to go and try to make a claim against the employer, both because they have the money and because a civil rights complaint about an unfair workplace is essentially one against the employer itself, Wayfarer Studios, as done by its agents. In this case, Justin Baldoni and Heath. So you're trying to set up a situation in which, to put it in college football parlance, the institution does not have control over its agents, does not have control over its people, did not engage in the proper setup for HR compliance, did not otherwise investigate complaints that were justifiably brought before them. The problem that you have, though, is that you don't really look like you made formal complaints. You can ascribe that to the fact that a formal complaint process wasn't put in place, but you know how to write a report. You clearly have expensive lawyers that are on retainer that can work for you at a moment's notice, can draft California complaints, turn that into a federal lawsuit, and otherwise work with you for that purpose. So as a method of looking at this from a resource and legal liability standpoint, I look at this and say, I don't know that you've made your case, that you actually went through the proper kind of protocol to actually see this get corrected. And when you did in January of 2024, if I'm to give you credit for everything that you've said in your lawsuit document, they fixed everything and finished the movie. That's a problem from a logic perspective for me. The parties negotiate a contract writer regarding Mr. Baldani's and Mr. Heath's conduct on the set of It Ends With Us. On May 2nd, 2023, the WGA, made up of 2 American labor unions, went on strike. Film halted production in June 2023. On June 15th, 2023, they announced they had halted production of the film due to the strike. While that strike was underway, there was a SAG strike. We know all this. We lived through it. The writer's strike ended on September 27th. The actor's strike ended on November 9th, 2023. Before returning to production, Ms. Lively attempted to address and resolve the problems on set and requested that Wayfarer agree to address the conditions described above. On November 9th, 2023, Lively's attorneys provided Wayfarer's attorney with a document entitled Protections for Return to Production, attached as Exhibit A. In conveying that document, Ms. Lively requested that Wayfarer agree to implement a plan that would enable everyone to return to work and complete the film with adequate protections to ensure a safe set moving forward. On November 11th, 2023, counsel for Wayfarer indicated that Wayfarer, Sony, and production respectively acknowledge that your client has concerns regarding safety, professionalism, and workplace culture. Although our perspective differs in many aspects, so this is the legal settlement document type way of saying, although we don't agree with your assumptions, we're not going to acknowledge that this happened or that we are guilty for it. Ensuring a safe environment for all involved is paramount, irrespective of differing viewpoints. We want everybody to feel safe, even if we don't agree that everything happened the way you said. Regarding your outlined requests, we find most of them not only reasonable, but also essential for the benefit of all parties involved. And you can frame this story as one that only happens because of the strikes. That's indeed what they're doing here. But going back to the previous paragraphs, I still have issue with how they described everything that happened before this point. On November 15th, 2023, Wayfarer, through It Ends With Us Movie LLC, its movie-making entity, agreed to the terms in a contractual writer, executed on January 19th, 2024, after that January 4th meeting. and attached to is Exhibit B. Among those provisions in that rider, an intimacy coordinator must be present at all times when Lively is on set. With respect to artists, any and all rehearsal, filming, reviewing of video playback or dailies or any other interaction with any scene involving simulated sex, nudity, or partial nudity shall be restricted to those persons with essential business reasons for being present, as approved by Lively and Todd Black, as further described in the nudity rider. The third provision required that there is to be no spontaneous improvising of any scenes involving intimate sexual physical touching, simulated sex, or nudity with respect to Lively. Scenes involving Lively that involve kissing, depictions of intercourse, or any other sexual physical touching must be contained in the screenplay, i.e. the most up-to-date draft approved by Lively in writing, choreographed in advance in the presence of the intimacy coordinator, and may only proceed as choreographed with the consent of all participants in advance. Fourth provision required physical touching and or comments on Ms. Lively's physical appearance must be done or made in connection with the character and scene work, not as to Ms. Lively personally, except as written into the screenplay or as strictly required in connection with makeup or costume preparation. There's to be no physical touching, including hugging, of Lively. There are to be no discussions with Lively of personal experiences with sex or nudity. No one will enter, attempt to enter, interrupt, pressure, or request entrance to Lively's trailer while she's in a state of undress. There shall be no rehearsal or filming of Lively of any nudity, partial nudity, or simulated sex except as expressly permitted in accordance with the nudity rider. There shall be no retaliation of any kind against Ms. Lively for raising concerns about the conduct described in this letter or for these requirements. Any changes in attitude, sarcasm, marginalization, or other negative behavior, either on set or otherwise, including during publicity and promotional work as a result of these requests, is retaliatory and unacceptable and will be met with immediate action. Now, we talked about this provision. It's in bold and italics for a reason as part of that first video. But this is important for a breach of contract complaint, right? This is a contract rider. This is one signed by everybody. These are provisions as part of making this movie that everybody has agreed to, and that if they don't oblige by, there can be a complaint for breach of contract. Now, this definition of retaliation, including sarcasm, a change in attitude, negative behavior, including during promotional work, is not retaliation as the law understands it, is not a negative employment action, is not adverse in the way that the Civil Rights Act is concerned with. That doesn't mean that you can't sign a contract that obliges you in a different way than the laws of the land do. And so you can have a breach of contract complaint if they can show that there was a retaliatory PR campaign issued against her and that it wasn't just organic and people saying that she was tone deaf in response to marketing this movie. But in this particular case, that's going to be a problem for breach of contract, not necessarily for civil rights and California law retaliation. We'll continue through the 16th and 17th provisions. The all-hands in-person meeting provided for in the contract rider occurred on January 4th, 2024. The meeting was attended as we described above. Production concluded and Ms. Lively and other cast and crew promoted the film according to the marketing plan. In connection with the film's public release, Lively and the rest of the cast actively promoted the film in accordance with the marketing plan. The marketing plan and related talking points asked them to focus more on the character's strength and resilience. It's a story of hope. Avoid talking about the film in a way that makes it feel sad or heavy. Ms. Lively and fellow cast members promoted the film in accordance with the talking points, but reasonable minds can differ as to how well they did it. You can comply with talking points and not do it terribly well. Mr. Baldani publicly embraced the marketing plan. In early May 2024, Mr. Baldani appeared at a floral-themed trailer launch event, which included him personally making flower bouquets for influencer, a photo opportunity, and film-branded latte art. Like, this is just a strange marketing campaign for a movie featuring domestic violence, but I'm not Sony. I'm not in charge of these things. As late as July 25th, Mr. Baldani appeared at a pop-up of Lily Bloom's Flower Shop in Century City, California, where he held a long-stem rose microphone and playfully gave tours of the shop to influencers. In a TikTok interview posted that day, Mr. Baldani excitedly walked through the pop-up and stated that he will be giving tours all day, every day, until August 9th. In advance of the release of the film, nearly all cast members chose to appear in public separately from Mr. Baldani, given his on-set behavior. And this probably should say on information and belief, right? As the lawyers for Blake Lively, you don't know why the other cast members chose to appear in public separately from Mr. Baldani. That they just appeared separately maybe happened, that they chose to specifically avoid Justin Baldani. You don't actually know that. So probably from a legal document perspective, you should be saying, hey, it's our belief that these people were specifically separating from Justin Baldani. Mr. Baldani became concerned that the public would discover that something is much bigger under the surface. On information and belief, alluding to the complaints lodged by Ms. Lively and others. Now, they're smart enough to say that they don't have any reason to know why Justin Baldoni said this. At this point, Mr. Baldoni pivoted away from the film's marketing plan to explain his absence from the rest of the cast. He shifted his focus away from a message of female triumph to instead capitalize on female trauma. After the film's premiere, Mr. Baldoni changed his Instagram profile, canceled lighthearted social media posts, and instructed his team to look for survivor reactions and support, all in an effort to quickly shift his own public narrative to focus solely on survivors and domestic violence organizations. And again, this is framed as he's a bad guy, he skeeves us out, nobody likes him. But the actual content of this paragraph is he chose to highlight the survivors of domestic violence, not actually a bad thing in any kind of objective framework in the world. Ms. Abel cautioned Mr. Baldoni that this shift might be too drastic too soon. Still, Mr. Baldoni insisted on a TikTok strategy and that his promotional activities for the film should seek to amplify what he described as survivor content. And again, the fact that Jennifer Abel says it might be too drastic and too soon, that's not indicative of anything from a legal perspective. We're back talking about things as if they were in USA Today. The team followed Mr. Baldoni's instructions. For her part, Ms. Abel concluded, "It doesn't feel performative now that you've done major substantial press on the topic." On August 11th, 2024, Ms. Abel laid out a posting timeline to Mr. Baldoni and the team, stating theater surprise, and then I think survivor content first thing tomorrow, AM, which then will be helpful for the news cycle. By repositioning Mr. Baldoni's marketing of the film on information and belief, Mr. Baldoni hoped to create the false impression that he had chosen not to appear alongside other cast members. Mr. Baldoni directed his team to share on his public Instagram feed the private messages he had received from survivors sharing their stories of domestic violence with him. Mr. Baldoni's team talked him out of these ideas, writing that they do not recommend using private DMs as content. And I've said in the past, both in this context and in others, sharing private DMs is a party foul. You really shouldn't be out there publicizing direct messages that you get from other people. Doesn't make it illegal, doesn't make it a breach of anything except maybe trust on the person sending you those messages. But it is likely a bad idea, and there's nothing really wrong with his PR team saying it is a bad idea. Mr. Baldoni went so far as proposing to share a video of a woman's birth moment, but his team talked him out of it, warning that it might be perceived as weird and too intimate. Still, Mr. Baldoni's team was more than willing to deploy survivor stories, reactions, and images to protect Mr. Baldoni's image. And again, a more positive framework might be to say that they were using the movie and their chance in the spotlight right this second to share survivor stories in a hope to limit the impact of domestic violence, to do good in the world. But that's certainly not the job of Lively's lawyers in the context of this complaint document, so I don't blame them too much for that. Mr. Baldoni and his team formulate a retaliatory plan. Wayfarer knew the details of Ms. Lively's and others' concerns, the HR complaints raised regarding Mr. Baldoni's and Mr. Heath's behavior, Ms. Lively's contractual writer, and the January 4th, 2024 meeting to discuss their behavior. In addition, Wayfarer's PR team knew about the claims by Ms. Lively and others, as well as the protections writer, as Wayfarer sent the materials to them in November 2023. Presumably along with the fact that Wayfarer denies the underlying facts that give rise to the protections writer. Like, knowing about the protections writer doesn't mean that you agree that everything happened in the way that Blake Lively or her team suggested happened in that moment. But that appears to be all this legal team has to indicate that they did know those things. As early as May 2024, Mr. Baldoni told his team that they needed a plan to get ahead of the claims against him in the event they were to go public. Specifically, Mr. Baldoni wrote, "Just want you guys to have a plan. Plans make me feel more at ease." And I said this in the first video, but they make me feel more at ease too. Like to have plans, like to know what's happening in my day. On May 17th, 2024, Mr. Baldoni texted his publicist, Jennifer Abel, that Ms. Lively's husband, that's Ryan Reynolds to you and me, had blocked him on social media, stating we should have a plan for if she does the same when the movie comes out. Again, nothing terribly legally concerning with any of these contents. In June 2024, a month after Mr. Baldoni's first promotional event for the film, Ms. Lively and others in the cast fulfilled their first publicity obligation for the film without Mr. Baldoni. They did not publicly discuss the misconduct that occurred on set, nor did they ever suggest to Wayfarer or Mr. Baldoni that they intended to discuss their concerns publicly. Yet on June 20th, 2024, Ms. Abel texted Mr. Heath her concern, "We can't have fans starting to guess why JB is left out of this stuff." Likewise, Mr. Baldoni strategized with his publicist, Ms. Abel, about various ways in which they might cover up or explain away his on-set misconduct. The message here appears to be, "Hey guys, one thing I want to do is the Dr. Amen show. Matt and I know you have your feelings about it, but his practice saved my friend Miranda's life a few months ago. With everything going on, I want to have an offensive move showing my neurodivergence and some of the attributes that come with it so that I can start talking about it. Most anything that I've been accused of is social awkwardness and impulsive speech, And I think me sitting down with him and just looking at my brain and talking about some of these things would be helpful for me. And again, they're using this to establish that they are going to take an offensive move showing neurodivergence to cover up or explain away his onset misconduct. Another version of this story can be that he sees Reynolds and Lively and maybe even the rest of the cast moving away from supporting him for whatever reason, and says, I'm going to need to have a plan of attack for if and when that continues to go down that road, right? And that doesn't assume that he did these various bad things that he's accused of. It may be the case that he is an impulsive, weird guy that you don't necessarily want to be around. I don't know. I don't know Justin Baldoni from Adam. I don't know Blake Lively or Ryan Reynolds, to be truthful. But this is not the kind of silver bullet of illegality that is described in the first sentence here, right? Ms. Abel about various ways in which they might cover up or explain away his onset misconduct. The same day, Ms. Abel reviewed again the agreed upon list of protections that formed the basis for the contractual rider. I don't know why that's included. On July 24th, 2024, Ms. Abel emailed Mr. Heath and others requesting the legal letter that was sent to Ms. Lively and her team, stating, per our conversation, we will go through point by point and draft context surrounding each situation. We can then flag what we are missing that would be helpful to arm us in the case we need to refute any of the claims. Bold and italicized. Yes, the PR person for the company and individual that is apparently at least being hinted at, accused of these various things in this protections rider, is articulating and forming a plan to refute those things should it come to public light. That is not a bold and italicized kind of concept in a PR context. And one of the things that is happening here, as we talked about earlier in this document, is that they are trying to make your ickiness about PR or crisis communications, which is legitimate. It is at least partially manipulative as a concept, into something that is illegal or that you should think of as illegal. And I do have an issue with that because I think communication specialists perform an important role, even if it can make us feel icky in certain respects. On July 26, 2024, Mr. Baldani sent Ms. Abel a Variety article about Francis Ford Coppola's inappropriate behavior on set during production of his movie Megalopolis. In conveying the article, Mr. Baldani stated, "This is the shit that I'm sure they want to do, unnamed sources, etc." Certainly, we talk a lot about unnamed sources here in Hangouts and Headlines. On July 29, 2024, Mr. Baldani and Ms. Abel discussed a proposal to get ahead of any potential publicity regarding Ms. Lively's HR complaints against him with a social and digital combat plan. Then they engaged Nathan and Tag on behalf of Mr. Baldani. We've seen that in the introduction about what they talk about with respect to burying and whatnot, the amount of money they're going to pay Nathan, all these various text messages. I do want to get to the counts here of what they're actually claiming happened here. The rest of this is still in the California complaint. You can see us discussing this in the first video in this series. It's a long document, folks. We'll get there, I promise. This is why we have to skip ahead sometimes, is because there's just too much that is all kind of small building blocks that don't mean a lot by themselves, that they're trying to put a picture on of what Nathan and Tag are doing to have their retaliatory campaign as described by them. We then get a couple of paragraphs about man enough, again, trying to frame Justin Baldani as a wolf in sheep's clothing and using essentially male feminism as an attack vector through his Man Enough podcast. They use various pictures and things to suggest that he is the real danger, etc. Until we finally, eventually get to the actual legal counts that they want to accuse Baldani et al. Of. First cause of action. Let's talk about it, folks. Took us a while to get here, but we've got a first cause of action. Sexual harassment in violation of Title VII. And this all goes back to Baldani sues the New York Times for defamation, says if any of this were real, she would have actually filed a lawsuit. That's an important point in all this. I said, and when I was making that video, because I knew that this lawsuit was already out there, that she would take up that particular gauntlet. And here she is, in fact, doing that. You've seen all those facts. We're going to accuse you of sexual harassment in violation of Title VII. For those of you that don't know, that's a part of the Civil Rights Act. It says, very helpfully for our purposes, it shall be unlawful employment practice for an employer to discriminate against any individual with respect to his sex. And I've highlighted in red the word his there. It's normal for statutes in the United States to be written with a kind of neutral male, but it is kind of interesting / unusual / not terribly good drafting for when we're talking about discrimination on the basis of sex to actually gender who might be discriminating on that basis in this particular instance. So to discriminate against any individual with respect to his sex, obviously that's her sex on this, but that's the bulk, right? We've got a lot of laws and rules and precedent that get passed and moved under this. But the notion is, in the United States, you can't be an employer that discriminates against your employees on the basis of their sex. That's one of the reasons why we have certain maternity provisions. It's one of the reasons why we have certain things that make sure that men and women are treated the same in terms of promotion and compensation in the United States. And it's one of the ways that you can protect yourself if you're Blake Lively or someone else in the context of a unsafe or bad workplace environment. Ms. Lively hereby repeats, reiterates, and reincorporates everything above. That's how these work. At all times herein mentioned, Ms. Lively was an employee of It Ends With Us Movie LLC, and Wayfarer were employers or joint employers for purposes of the law. That's going to be unobjected to. At all times herein mentioned, Title VII was in full force and effect. The law didn't change and is binding upon the employers. Ms. Lively's sex and gender constitute a protected class under Title VII. In engaging in the conduct described in this complaint, defendants It Ends With Us Movie LLC and Wayfarer, through defendants Baldani and Heath, discriminated against Ms. Lively in violation of Title VII by subjecting Ms. Lively to harassment and creating a hostile work environment on the basis of her sex and gender. Now remember, this is essentially a multi-tiered complaint document. This is sexual harassment in the first instance. That's what we're talking about right now. And then it's going to become retaliation for reporting on that harassment. So she has to prove the harassment. She has to prove that she went through and tried to stop the harassment. And then she has to prove that what happened after that point in time was retaliation for purposes of the law because of the reporting / harassment. The behavior of defendants Baldani and Heath, as described in this complaint, was severe or pervasive, such that it created a work environment that a reasonable person would perceive, and that Ms. Lively did perceive, to be hostile, intimidating, offensive, oppressive, and or abusive. Defendants It Ends With Us Movie, Wayfarer, through defendants Baldani and Heath, perpetuated this environment by failing to create a workplace in which individuals felt comfortable raising concerns regarding harassment and other inappropriate behavior on set, including in Wayfarer's failure to provide Ms. Lively with an employee handbook, all the rest of the documentation we talked about, and comments by defendants Baldani and Heath undermining HR concerns. The conduct by defendants Baldani and Heath, including but not limited to the conduct described in paragraphs above, is in direct violation of Title VII. These actions severely impacted Ms. Lively's physical, psychological, and emotional well-being by creating an intimidating, hostile, and offensive working environment. The defendants we talked about are liable because they co-own and operate Wayfarer, the sole member of It Ends With Us Movie LLC. It's all a corporate structure. Personally committed the harassing conduct. Yeah, that'll get you if you personally commit it. And were therefore aware of their own conduct and failed to make immediate and appropriate corrective action. Further, defendants Wayfarer and It Ends With Us Movie are strictly liable for the actions of defendants Baldani and Heath, who were acting in their capacities as Ms. Lively's supervisors. Again, even though we have that section in this complaint that says we filed grievances and they didn't investigate, even when we get to this actual part where we're trying to establish the essential factors of what constitutes an issue under the law, we say they're liable because they knew what they did, they didn't correct it, not that we went through a formal reporting procedure. And part of what their defense is that they didn't have a formal reporting procedure. That might be good enough, but it does present at least a certain weakness on this particular score. Harassing and retaliatory conduct against harassed Ms. Lively continued in various forms throughout 2024, and on information and belief is continuing, including a coordinated campaign to cast Ms. Lively in a false light, to discredit her in the event that she publicly disclosed her concerns about harassment and other unlawful conduct, and to irreparably damage Ms. Lively's career and future earning capabilities. And here's where we start to get into a little bit of trouble. I talked about adverse employment actions as part of this, right? What retaliation means under the law. And we're past where she's employed by It Ends With Us Movie LLC or Wayfarer. We're past that point in time. And so they have to start saying that this campaign is retaliation and it's an adverse employment action because it's damaging her career and future earning capabilities, even though they don't have an employer relationship with her anymore. So they're going to have a certain legal soft spot here, and we'll see it even more completely as we continue on looking at these counts. As a direct, foreseeable, and proximate result of this unlawful discriminatory conduct by defendants, Ms. Lively has suffered and continues to suffer substantial damages, including but not limited to severe emotional distress and pain, humiliation, embarrassment, belittlement, frustration, and mental anguish, and is entitled to an award of punitive damages in an amount to be determined at trial. So when we're talking about legal concepts, normal damages are, I got hurt this much. And we can put a number on that in the law that says, all right, I was emotionally distressed in this fashion, and that's worth a couple $1 million to me under this particular law or precedent in this jurisdiction. Or I lost this job, and that's definitely worth what they would have paid me to do this job. And so those are direct damages. But this is so bad that I should get punitive damages, punitive standing in for punishment in legal documents, meaning we can also ask for more money to make sure that they don't do this again. The conduct described herein by defendants was a motivating factor in causing and caused Ms. Lively's harm. Defendants, It Ends With Us movie and Wayfarer intentionally violated Title VII with malice or reckless indifference and are liable for those punitive damages. So not only did they do this bad thing, they were malicious about it. They were recklessly indifferent about it. They didn't care whether anybody was harmed by their actions. And so we're not just owed what are direct damages that are maybe easier to prove in some fashion. We're also owed whatever the court deems appropriate to give us to punish the people that did it. Second cause of action, retaliation. Ms. Lively hereby repeats, reiterates, realleges, and reincorporates everything above. We did all the preamble stuff. The law is still in place. Ms. Lively engaged in protected activity by complaining to Wayfarer, Mr. Baldani, and Mr. Heath about harassing treatment based on sex and other unlawful conduct on multiple occasions during the filming and production of the film, which Ms. Lively reasonably believed to be unlawful. So here's where they say that she reported things, right? We didn't get a lot of clarity on that. See paragraph 6879. That's not going to help us. But even though we don't get a lot of clarity on that, this is what they have to allege here. She reported on this, and then they retaliated based on those reports. After Ms. Lively engaged in such protected activity, defendants subjected Ms. Lively to adverse employment action, there's that language, including but not limited to, by launching a coordinated campaign to cast Ms. Lively in a false light during the publicity and promotion of the film and thereafter. Ms. Lively's protected activity was the motivating reason for and but-for cause of defendant's conduct. This harassing and retaliatory conduct continued in various forms throughout 2024, and on information and belief is continuing. They're still engaged in that campaign right now in order to discredit her in the event that she publicly disclosed her concerns. Well, we're very publicly disclosed now, aren't we? As a direct, foreseeable, and proximate result, the defendants, through the actions of Baldani, Heath, and Sarowitz and their associates, Lively suffered all these various bad things, and they should get punitive damages. Again, they were intentional, or they acted with malice or reckless indifference, and they are liable for those punitive damages. And that's the retaliation concern. But like I said before, we've got certain issues with that. When we talk about retaliation, we're going to look at a Cornell article here. This is not law or anything like that, but we can start to get the context of what I'm talking about. Adverse employment actions and hostile work environments are examples of circumstances that can support a claim under Title VII. Adverse employment actions are actions that cause a significant change in employment status, such as hiring, firing, failing to promote, and reassignment with significantly different responsibilities. For example, an employee's reassignment to a more arduous and less prestigious position due to her gender constitutes an adverse employment action. So it doesn't have to be just a firing. It doesn't have to just be a hiring or a promotion. It doesn't have to be that kind of terminal or obvious. It can be things in between, which we will see mirrored in California. If I can skip ahead here to what I've got. Adverse employment action for purposes of a jury instruction in California. This is important because she's also going to bring these claims not just under the Federal Civil Rights Act, but also the California versions of the same. Adverse employment actions are not limited to ultimate actions such as termination or demotion. There's an adverse employment action if, name of defendant, Blake Lively, defendant here is Justin Baldoni or Wayfarer, has taken an action or engaged in a course of pattern or conduct that, taken as a whole, materially and adversely affected the terms, conditions, or privileges of Blake Lively's employment. An adverse employment action includes conduct that is reasonably likely to impair a reasonable employee's job performance or prospects for advancement or promotion. However, minor or trivial actions or conduct that is not reasonably likely to do more than anger or upset an employee cannot constitute an adverse employment action. The important part here is of Blake Lively's employment, right? We are past the point in time where Blake Lively is employed by Wayfarer, or by It Ends With Us movie LLC, or by Justin Baldoni at all. We're at a point in time where we're talking about PR, and whether or not that's retaliatory for purposes of the acts we are discussing is going to be an important part of this particular case, because I personally am not sure it is, even if we assume everything in this complaint is exactly as Blake Lively says it is, that he was a sexual harasser. He created a hostile work environment. Neither Wayfarer, nor It Ends With Us movie, nor Sony, or anyone else did anything about it. This is not a place where anybody should have to work. It's not something that Blake Lively should have had to go through. But the fact that they then engaged in a deliberate astroturfing or otherwise manipulative PR campaign does not appear to easily fit into the bucket of adverse employment action for purposes of this law. And that's a problem because that's the main thrust of huge sections of this particular lawsuit. Third cause of action is the California version of everything that we just talked about. And California's law I can pull up. It's very similar. It is an unlawful employment practice for an employer because of sex to discriminate against a person in compensation or in terms, conditions, or privileges of employment, right? Of employment, super important there. What does that mean in this context? I haven't seen a lawsuit, I don't think, that talked about social media PR campaigns in this way. Can that be retaliation for this? Can it be retaliation for this with such a weak kind of through line of reporting, right? You don't really establish as part of your complaint that you talk to anybody in a formal way. You say that that's because they don't have a formal process. That's fair. Parts of your complaint document are totally fair. I would not want to work in the environment that you describe in your lawsuit. That is fair. But I'm not sure you get to the point in time where you say PR people doing PR things is retaliation as an adverse position of employment, right? There's no discrimination happening to your terms, conditions, or privileges of your employment because your employment doesn't exist anymore. And to the extent that it does for marketing purposes of this film, we're past the point where this is doing anything to your terms and conditions of employment. Fourth cause of action is retaliation for purposes of that same California code. Again, the California code is written very similar to Title VII of the Civil Rights Act, so it's the same kind of thing. You can't retaliate against a person for pursuing their rights for a violation under that California Act. Specifically, pursuant to 12940H, it is an unlawful employment practice for an employer to discriminate against any person because that person has opposed any practices forbidden under that law or because the person has filed a complaint against conduct prohibited under that law, as Ms. Lively did when she complained to Wayfarer, Baldani, and Heath about harassing and other unlawful conduct based on sex, which occurred throughout the film's production. Ms. Lively engaged in protected activity by complaining to Wayfarer, Mr. Baldani, and Mr. Heath about harassing treatment based on sex and other unlawful conduct. After Ms. Lively engaged in such protected activity, defendants subjected Ms. Lively to an adverse employment action, including but not limited to by launching a coordinated campaign to cast Ms. Lively in a false light. And again, this might well fall under the definition of retaliation under that contract writer, under that provision. So there might be a breach of contract complaint, and we'll see it later in this document. But based on what's an adverse employment action, this appears to be a novel theory. I don't believe I've seen before that launching a coordinated campaign to cast aspersions on an actor is an adverse employment action for purposes of this law. And you can say, well, maybe the law isn't written properly to cover this. You always have to be careful when you're writing laws, make sure you don't become over-inclusive or under-inclusive. Maybe this is the wrong law to be suing under for purposes of this. I don't know. I can't speak to those things. I didn't draft this document. I'm not Blake Lively's lawyer, but I can point out the holes where I see them. And one is that launching a coordinated campaign is something that I don't know that you've proved to exist. I know we skipped that section in discussing this particular complaint, but I don't know that you've proved it to exist. And if you did, I'm not sure it's an adverse employment action for purposes of retaliation under the Civil Rights Act or your equivalent in California. As a direct, foreseeable, and proximate result of the unlawful retaliatory actions undertaken by these folks, she suffered and continues to suffer all the bad things we talked about before. We're entitled to damages. They committed the acts maliciously, fraudulently, and oppressively with the wrongful intention of harming Ms. Lively in violation of her rights and acted in a manner warranting punitive damages. We're going for big money here, folks. Ms. Lively hereby repeats everything above. For the fifth cause of action, retaliation in violation of the labor code. California has a lot of layered statutes just like everyone else. So we'll talk about that as well. I think I have that one ready. We'll see. Maybe I don't. Don't think I pulled up the labor code. It's a very similar kind of concept to what we already saw before, but I don't have the labor code ready. I'm sorry to say, everybody. So if you were excited about seeing the California labor code, I don't have that one to pull up. At all times mentioned herein, California Labor Code 1102.5 was in full force and effect, and it's good for us to reference here. Pursuant to California Labor Code, an employer or any person acting on behalf of an employer shall not retaliate against an employee for disclosing information to a person with authority over the employee or who has the authority to investigate, discover, or correct a violation of law. Section 1102.5 additionally prohibits an employer or any person acting on behalf of an employer to retaliate against an employee for having exercised their rights. So very similar to what we saw in the main California law. This happened when she complained to Wayfarer, Baldani, and Heath. Ms. Lively engaged in protected activity by complaining, and then they're going to get to unlawful retaliatory actions as a result of this campaign, right? Perpetrated by the defendants, was a substantial factor in causing her to suffer. We should get punitive damages, et cetera, et cetera. Sixth cause of action, failure to investigate, prevent, and or remedy harassment in violation of the California Code. And this is closer to accurate, right? All the retaliation stuff I have a problem with because I don't know that it's an adverse employment action for purposes of the California law or the federal law, but a court might be convinced on these various things. In this case, failure to investigate, if that is in fact what happened, if there was a proper procedure followed of some kind, if a formal complaint was filed and there was no investigation, and it isn't just the paragraphs written above that, of course, they weren't going to investigate themselves, and so we're just going to skip ahead. This could be an actual problem under the laws of California and the federal laws. Ms. Lively repeats everything above. At all times mentioned, Ms. Lively was employed by the defendants. Specifically, 12940J and K require employers to take all reasonable steps to prevent harassment and makes it an unlawful employment practice for an employer to fail to take all reasonable steps necessary to prevent harassment from occurring. Ms. Lively was subjected to harassing and other unlawful conduct based on sex, which occurred throughout the film's production. And again, if it is exactly as she says in this document, I think that that does probably establish a hostile work environment. Ms. Lively complained to Wayfarer, Mr. Baldani, and Mr. Heath about the conduct she experienced, but Wayfarer failed to take all reasonable steps to prevent the sex-based harassment and retaliation suffered. We don't know what kind of way that complaining took place because they didn't have a formal process, at least as alleged in this document. She suffered all the emotional distress and pain. They deserve punitive damages. We've seen all this before. Then we get into the weird ones. Seventh cause of action, aiding and abetting harassment and retaliation in violation of California law. And this is aimed at the PR folks. Defendants Nathan, Tag, and Abel, as individuals and entities that are not Ms. Lively's employer, aided and abetted the discriminatory conduct of defendants It Ends With Us Movie LLC, Wayfarer, Baldani, and Heath, including but not limited to by participating in the above described coordinated astroturfing campaign to discredit and bury Ms. Lively. This is rough, right? So aiding and abetting means specific things. When we talk about harassment, when we look at the California law, it's bad to aid and abet harassment. But is a PR campaign done largely after the fact aiding and abetting harassment by essentially covering up or hurting the ability of a complainant to make their case public about what sexual harassment occurred? Ostensibly, the legal system should not be terribly influenced by what PR or crisis communications managers do out there in the public eye. So it's unclear how they would be affected on a legal basis. But here I really have an issue with kind of expanding the capability or the liability of the law to PR officials that are essentially doing their jobs of trying to make their client look as good as possible. And in terms of burying Ms. Lively, the one thing that they said in all those texts, and I know it was used as a silver bullet to explain that they were bad people, but the thing that they said in their texts was that they can't say that they can bury anyone, even though they know that they can. As a direct and proximate result of defendant's unlawful discriminatory conduct, plaintiff has suffered all the bad things. Defendant's conduct was willful, and they knew that their actions constituted unlawful violations of FEHA. Now, that's impossible, in my opinion. They couldn't possibly know that performing services on a communications basis, as they described, was a violation of the California civil rights laws on a sexual harassment basis. There's no obvious through line to, I'm going to make a article appear in my favorite periodical that says Justin Baldoni is a great guy, is aiding and abetting or a violation of the sexual harassment laws in the state of California or otherwise. That is not at all obvious to me. And if I'm the PR people, I'm fighting this to tooth and nail. Mr. Sarowitz, Ms. Nathan, Tag, and Ms. Abel intentionally violated Ms. Lively's rights. under the California law, acting with malice, oppression, and or fraud. Therefore, they're all liable for punitive damages for reprehensible conduct of the reprehensible conduct of Mr. Baldani and Mr. Heath, in an amount necessary to punish them and to discourage future wrongful conduct. And I say this so that you can hear me analyze it this way, but I don't begrudge the lawyers from throwing everything they can at the wall, everything in the kitchen sink, to try to get Baldani and the people that they feel have harmed their client any way they can. But I do think that this, if it were to be upheld, presents a dangerous precedent for all communications, online or otherwise, that you can be held liable essentially for underlying acts that you might not have any knowledge of, because your client says some negative stuff might come out about me, and I need to make sure that it's more positive than negative out there in the sphere of public opinion. So this one bothers me. Maybe it bothers me as a commentator or a communicator myself, but I don't begrudge the lawyers for making it. I just don't think it should hold up very much in court. I don't think it will, honestly. And then we get to the one that I think is a lot easier, which is breaches of contract, the 8th cause of action. We repeat everything above. There was a loan-out agreement between Blake Lively's company. So apparently the structure that Blake Lively uses, and I suspect a number of actors use, is that she has a company that she operates under, presumably as the sole owner of, and it's called Blakel Inc. And Blakel Inc. then signs an agreement with a movie studio that says, we'll make Blake Lively available on certain terms. And in that term, paragraph 7 strictly prohibited sexual harassment. Yeah. General compliance with law is often in these contracts. So yeah, seems fair. Paragraph 7 of the agreement prohibited any punishment or retaliation against another for his or her refusal of such harassment. Refusal of the things that underline such harassment. Everybody refuses being harassed. Though through defendant, Wayfarer, defendant It Ends With Us Movie LLC, Baldani and Heath, they repeatedly violated paragraph 7 of the agreement. Okay, sure. That doesn't really add anything. If you've got them on a violation of the law, you'll have them on a breach of contract under these terms. And then breach of the contract writer, right? We talked about this. Paragraph 10. Paragraph 10 of the writer strictly prohibited It Ends With Us movie from retaliation of any kind against Miss Lively, with their strange and broad definition of retaliation, including sarcasm and changes of attitude, etc. Ms. Lively is entitled to enforce the contract writer. Yeah, sure. Through defendant Wayfarer's conduct, defendant It Ends With Us movie, breach of its obligations under the contract writer agreement has caused and will continue irreparable injury. Such breach of obligations was a substantial factor in causing Ms. Lively harm. Yes, you see, they start as strong as they can and then kind of go down in order, because even though this is easier to prove, a direct damages claim for breach of contract isn't the most lucrative or helpful to them. And so that's why it's 9th. 10th is not easy to prove, intentional infliction of emotional distress, but it's also just kind of a throw-in at the end of one of these. You've already said in all the other contexts that the sexual harassment has caused you emotional distress, the retaliation has caused you emotional distress, everything else has caused you emotional distress. So you might as well claim emotional distress on its own as part of one of your counts. But I think the breach of contract complaint is very strong insofar as they agreed to a definition of retaliation that, in all honesty, I don't think they should have. Like, the breadth of that, change in attitude being retaliatory, is crazy to me. I would have had notes if I were on the other side of negotiating that particular document. Maybe they did and they just got overruled. But I think breach of contract probably does hold up. Again, assuming that what Blake Lively and her team has said here is at least in part accurate. 10th cause of action, intentional infliction of emotional distress. It all tags back to what we talked about. And then negligence, infliction of emotional distress. And I said lawyers make typos, folks. This should be negligent. They need the adjective there. Negligence is a noun. Negligent infliction of emotional distress. So they either intentionally caused that distress or they just didn't care. At all times, it was reasonably foreseeable that Ms. Lively would suffer harm if they continued to do what they were doing, and they let her suffer harm anyway. They were negligent. Finally, we have the kind of defamation claim. Again, there's defamation claims flying all over the place against each other here. 12th cause of action, false light, invasion of privacy. As alleged herein above, the defendants publicly disclosed information or material regarding plaintiff's marketing decisions, moral character, private life, and family, which showed Ms. Lively in a false light. The false light created by the disclosures of these defendants would be highly offensive and objectionable to a reasonable person in Ms. Lively's position. And then it made Ms. Lively the object of scorn, pity, ridicule, humiliation, and other suffering. One aspect of this that is interesting is that this isn't a formal libel complaint, right? We have Justin Baldoni suing the New York Times for libel. We'll also see that he sues Blake Lively and everybody in her orbit for libel. False light, invasion of privacy is a little bit different. It's essentially the surfacing of true-ish information in a way that implies things that are bad about a person. And that's what the accusation here is about the PR campaign, is that you're floating bad things, you're astroturfing various things in order to hurt our client. And even if any given thing might be true in isolation, the overall feel of it is to create this false light on our client, and that in of itself should be illegal, and everybody is the defendant on this. As a direct and proximate result of the said publicity and false and misleading disclosures, Ms. Lively was harmed. They did it with oppression, fraud, and malice. Therefore, she should get punitive damages and then more sexual harassment under a different section of the California Code. I think we know what's happening here. We would ask for money. We'd ask for emotional distress money. We'd ask for interest. We'd ask for penalties. We'd ask for punitive damages. We'd ask for attorney's fees. And we'd ask for anything else the court wants to give us. And we'd like it to be done in front of a jury. Why? Because if you're going to have a sexual harassment lawsuit seen, you'd rather have it be seen by individuals rather than the judge, because you are making an emotional plea in your documents here. And the general thought process among lawyers is that if you've got the emotional argument to make, you're better off with a jury than a bench trial. And that's fine. You're entitled to a jury trial on these things. But that's why you see it this way. That's 93 more pages of legal documentation that we have gone through in Hangouts and Headlines. And I did want to say hi to a friend in the chat really briefly that I saw pop in momentarily. If I can hit these buttons correctly. I don't know if I can, so bear with me. Saw Emily Baker was here. I don't know if she's still here. She's a busy woman. But she says, glad to see you, Hoeg and chat. Love Hangouts and Headlines. We love you, Emily D. Baker. I've told people that want a more consistent framework for having folks comment on these lawsuits and articles to go see you. I know that all of my colleagues are basically talking about all sorts of legal issues at a much higher cadence and consistency than I am at this moment in time, trying to get there, folks. I really appreciate the support, but it is great to see you, EDB. And I am very glad that you popped in for us. I know that you like Hangouts and Headlines, and I very much appreciate you for doing so. And that's the legal document. We talked about the AP reporting. We talked a little bit about the law. I also wanted to talk a little bit about the aftermath, because as part of all of this happening, Justin Baldoni and his team have decided that they are going to release snippets and text messages and voicemails and shots of various things that happen behind the scenes so that they can let the public choose what to believe about these various anecdotes and stories. On the sexual harassment side of things, they are denying that there's a retaliation campaign in place at all. But they want to say that everything that Blake Lively said about the sexual harassment side is in error in some way or is obfuscatory in others. And so they release things like the dailies of that scene about the lip biting and what was said for a slow motion reel, and they say it proves their case. Justin Baldoni releases unedited. It ends with us footage featuring Blake Lively. But we're not going to go into that too much. We're definitely not going to play other people's videos on this channel. But we are going to say that that led to another fight behind the scenes, which is to say that, thank you for all this advertising website, Blake Lively, Ryan Reynolds seek a gag order against Justin Baldoni's lawyer as part of that New York case. Or as this Hollywood Reporter article says, the back and forth continues, leading to a request from Team Lively as part of the New York case that says, on December 20th, 2024, Ms. Lively filed an administrative complaint with the California Civil Rights Department. That's the very first thing we looked at as part of this series. A requisite step in exhausting her administrative remedies prior to filing suit in California. Immediately thereafter, through counsel, Ms. Lively provided the named defendants a copy of that complaint. At the same time, Ms. Lively also issued the Wayfarer parties a cease and desist letter, demanding that they immediately cease and desist all unlawful conduct towards the Lively Reynolds parties and their affiliates, including their harassing and retaliatory media and online campaign against Ms. Lively. So, again, their accusation, as we just saw in their lawsuit in New York and in their complaint document in California, is that I was sexually harassed on the set of this movie, and then the PR campaign against me afterwards is a retaliation for that. Both are illegal. And so what is happening here is this law firm sends a cease and desist. It says anything you're doing out there in the public sphere about PR for Justin Baldoni or against Blake Lively, all of that should stop because it's illegal. We just sued you over it. Immediately thereafter, and virtually every day since, Mr. Friedman, that's the lawyer for Baldoni, has given television interviews, appeared on podcasts, issued inflammatory written statements, and leaked information to the Hollywood press and tabloid media. Those statements not only continue the campaign of retaliation that was the subject of Ms. Lively's first cease and desist, but they contain numerous new false statements against Ms. Lively and others. So from Lively's perspective, again, let's give her full credit here, assume everything here is true. She feels there's retaliation, it's illegal retaliation, and then when I make this complaint, which will eventually become the lawsuit we just read, the lawyers for the other side immediately start putting out information like the dailies we were looking at, like the various other things that you can see in your social media timeline of voicemails and text messages, and says, okay, if you are engaged in a campaign of retaliation and that's illegal, you should stop that right now because all of this is part of that campaign. Understanding, of course, from Baldani's perspective, if it's not a campaign of retaliation, if he feels like he's being put upon by an actress that has seized edit and control of his film, we saw all that in his lawsuit against the New York Times, that this is all essentially an attack on him, then this is getting the truth out there, and that's a defense mechanism, and there shouldn't be a gag order. But it's justifiable from the Lively perspective to say, if this is illegal, judge, you can't just wait for us to get to court. That's going to take a year or more. You should issue a gag order right now, even though it looks completely unfair from the other perspective. And that's why a court should probably be resistant to this kind of claim, because we are fully in the area where we don't know any facts for real. We are still looking at complaint documents from both sides, and each is alleging essentially an opposite version of the universe to the other. That, yes, this makes sense from the Lively perspective of the universe, but a court should be reluctant to use its equitable powers, its ability to enjoin someone from asserting its First Amendment rights to speech in a case where we at least have a reasonable perspective that Team Baldani might be in the right here versus Team Lively. On the other side of things, I've also seen on social media and other places, people saying that Baldani and his lawyer are just trying to pollute a jury pool. I really don't think that's a justifiable concern in this particular area. The jury pool is too large for this purpose, and we really don't know what people are going to know. So to the extent that Baldani wants to get some of this information out there, and he feels like he is actively being defamed by the campaign of Team Lively, I am very sympathetic to wanting to get more of the information out in the public sphere. And we've already seen that the Lively side of the equation here has said that that daily that we're not playing the video of, but that you can see on your social media, that I will try to link to in the description of this video, proves their case, while Baldani says it proves his case. So we're fully in he said, she said territory. We're fully in reasonable minds can differ. But I always get concerned about gag orders in lawsuits, because there's a very, very strong First Amendment protection for people to speak in the United States. And in the context of this, where we've got defamation claims on both sides, where people are arguing that the other side is actively harming their career and livelihood prospects, that to give a gag order in that context before discovery, before a trial has taken place, I think is unwarranted. But that is the request that Blake Lively and her team have made. That is all going on in the background. Also going on in the background, and presumably on another episode of this show, if I can get up the energy to do another 2.5 hour long stream with y'all, is that Justin Baldoni has not stopped his defamation lawsuits with just the New York Times, but has in fact sued Blake Lively and Ryan Reynolds, my favorite, for defamation on their own part. So this is continuing to escalate very quickly, as Ron Burgundy might say, and we have a lot to go over in this space, a lot more than I thought when I started the first video of this series. But that's what I wanted to talk to you about today. Hopefully I offered some insightful commentary to you all. In the meantime, if you like this commentary, these conversations in this space, please consider supporting the channel through memberships. We're going to do a few more member early access videos on this channel, or through super chats, or through Player, Patreon, anything else that you want to do. Or if none of that's available to you, I don't want anybody to go bankrupt supporting my silly YouTube channel. Please just consider subscribing, telling your friends, letting folks know that we're having good conversations about important topics in this space. Otherwise, let me know if you've got any questions or comments or things that you think I missed, or that you'd like a little bit more clarity on before we go for the day. And I will see you on the next episode of Hangouts and Headlines, Virtual Legality, Bitcast, or anything in between. Thank you so much for being here. Let me know if you have any of those comments. Stephanie, who says, we hope you do more long streams, but only if you're feeling up to it. Health comes first. I can promise you that I'm not going to do one of these more than once a week. These long streams. I know that that's really all I can do. So if you see me do one on a given week, you can assume that if there's a sequel or if there's something else that happens, that stream is not going to be until the next week. I am trying right this second to get to a cadence of essentially one virtual legality and one Hangouts and Headlines long form stream per week, with the Bitcast and appearances on Last Stand Media, and also accompanying those various things, and running a law firm and trying to do more stuff for my clients and legal work at the same time. But I very much appreciate all the support, and everybody has been very patient with me working through the last 2 years, and I really, really appreciate it. Catherine Frazier says, thank you, Rick. Thank you, Catherine, for being here 2.5 hours in, hearing me talk about these things. I really appreciate all the support from everybody, including from my awesome wife, Mrs. Hoeglaw. You're doing great, Rick. Thank you, honey. I am feeling good. We're making it to the 2.5 hour mark. We're doing it. Fantastic. I'm glad to have these videos out there. Christy Fletcher says, put off doing dictations to listen. Smiley emoji. It's okay. Still got Discovery scheduled. So glad to catch a live. I had to move the Stephanie Jones lawsuit off the schedule because I wanted to get to this, and then ultimately the 180 pages Justin Baldoni has for us on the next episode. But I very much appreciate everybody sticking with me, and I certainly understand and will happily send you to all the great colleagues in the LawTube space on YouTube or in podcast form that are talking about these things much more quickly when they've happened, when they are filed. I know a lot of the articles we talked about today and the documents that we talked about today are late December, early January, but I very much appreciate those folks that are interested in my opinion on these things. Allison Gunnell says, you're doing amazing, Hoeg. I don't think we often see it in ourselves, but we see it for you. I am doing my best. I really appreciate it, Allison. Shiny heart emoji, shiny heart emoji, XX. Well, you know, Mrs. Hoeglaw is in the chat. You got to watch it with those X's, but I really appreciate it, Allison. Thank you so much. Against the Tide, who is a mod at the channel and is always here. Very, very thankful for her support. Says, you are all awesome. I couldn't agree more, Tide. My idea. This was great to hear your input on this. Have missed your deep dives on these kinds of things. Glad you're doing so much better. I'm glad to be doing better. I am really trying. BNNT, why content do you like hosting the most, Rick? Games or legal cases? That's really interesting. I like talking about media. That's what Hangouts and Headlines is. It's become a kind of legal deep dive on this particular issue, but I love talking about media. That's what I was doing during Depp v. Heard. It's why Hangouts and Headlines exists. But virtual legality is my baby. That's really when I started making content at all. I wanted to talk about legal questions. I wanted to talk about process. I wanted to talk about important issues in the context of something that maybe wasn't as important. That was the idea behind virtual legality. In a way, that's the idea behind Hangouts and Headlines. So that's what I like to do. I like to talk about important stuff with maybe not as much of the baggage as you might get from outraged social media, politics, discourse, whatever it might be, while still talking about things like the structure of the U.S. government or how lawsuits work against each other, or what's happening when you pick some place like California to bring your defamation claim against the New York Times. I think I can add insight there, and ideally that's what I'm doing. Dutton E says, as a fellow lawyer, this is pretty cool to see. Well done. Thumbs up emoji. Thank you, Dutton. I really appreciate it. I am glad to see you here, and I appreciate the support. Emily says, I love getting different perspectives on the same lawsuit personally. Yeah, I think it is undoubtedly the case that if you go to Emily D. Baker's coverage, who was here earlier in the chat, may still be here, it's going to be different. It's going to highlight different things. She's going to see different things than me. She's a prosecutor, and she has more of that litigation experience than I do. But I do have the ability to read legal documents, and hopefully that's adding some insight from my perspective as well. Laura Boyd asks, you said many of Blake's complaints do not rise to the legal definition of work harassment, but those seem to apply to usual work environments. Could Blake's lawyers argue that her situation is unique? Absolutely. I mean, that's the job of the lawyer, is to say, okay, so we put these building blocks in place, and they might not rise to the level of being a harassment complaint in a law firm setting or even on a factory floor setting. But in this particular case, this is harassment, and you should know that because we've got these guild protections. You see some of that in the paragraphs that say the reason that we have nudity writers, the reason that we have these various things is that this is a particularly vulnerable situation. Ordinarily, if you're working at a law firm, there is no place or capacity in which you might be showing someone a video of your wife giving birth that could be justified. Baldani might be able to justify that. Heath might be able to justify that. But that's why we have certain contractual writers in place for those things. And you can argue those points as we get going. What I wanted to point out as part of the complaint document, both in California and as kind of copy pasted into the top of this document, is that there are certain narrative tricks that are done that are not illegal. They're not certainly going to result in sanctions for the lawyers. They're all within the realm of possibility for how you frame a legal document, but that they're still happening, that we can still use what we're learning in Hangouts and Headlines. We can still use the way that we critically read everything that we see in all of these various capacities on a legal document like that one. And hopefully, if we're ever in charge of writing something for the New York Times on a complaint like that, we will know when to use alleged and when we can't skip using alleged and not wind up getting sued for defamation on those particular complaints. Allison says, sorry, I think it's a British thing with the X's. I was just joking, Allison. I appreciate the X's. I am sure Mrs. Hoeglaw does not take offense whatsoever. Thank you for the smiling, laughing emoji. There is no offense given. I'm just joking around with you. I really appreciate you being here. Ms. VG3 says, I most appreciate the critical look at the media coverage, which can color an issue so subtly. Thanks, Hoeg and co-counsel. Peace sign emoji, heart emoji, newspaper emoji. Thank you, Ms. VG3. I am very glad to be participating in these conversations. And please do, if you're still here, leave a comment. I love responding to those comments as much as I can. Part of the reason I do these in Virtual Legality or Hangouts and Headlines is I like to create spaces where a community of people that are interested in critical thinking, that believe in reasonable minds can differ, can have these conversations. And I try to comment on these things as much as possible. If I miss you, it's just because I haven't been on my comments for a little while, but I do try to respond to as many as I can. So leave a comment with those thumbs up, with those thumbs down, whatever you choose to do, it's fine with me. I really appreciate it. As Ms. Hoeglaw says here, no offense whatsoever. Hoeg is a cutie. Oh, I'm going to blush. Thank you. Smiley face emoji. I appreciate it, Mrs. Hoeglaw. Thanks for sticking with me through all these. And thank you to everybody in the chat and otherwise. I will see you on the next episode of Hangouts and Headlines, Virtual Legality, or whatever video I wind up putting up on the channel. Thank you so much for being here. I really do appreciate it.
Virtual Legality is a YouTube video series with audio podcast versions presented as commentary and for education and entertainment purposes only. It does not constitute legal advice and does not create an attorney-client relationship. If you have legal questions about the topics discussed, please consult your own legal counsel.